the various places. He has been trapped in a case. If your lordship
What do you want? What do you
my
want?
lord, the listing of the case.
Give the memo.
My lord, fresh in case tomorrow it can be taken up.
Not tomorrow. Just see.
Next week, 20th, 21st, I want to be there.
20, 20?
20th and 21st, I want to be there.
20th, 21st. Chhadi gaya kut lagdi hai. Yes.
My lord, next week kindly, your lordship.
Yes.
My lordship's indulgence to mention a matter.
Yes.
This matter has been heard by your lordship so many times, but your lordship also directed the matter to be in the board. But unfortunately, it is not in the board. Can it be listed tomorrow, your lordship?
Which matter you're talking about?
That is a criminal appeal number 717 of 2007. My friend, colleague is there.
My lord, CRLMC 390.
I'll include it.
Please, lordship, so that it can be heard tomorrow if your lordship. Because it has been heard so many times, your lordship.
My lord,
Please, lordship.
my lord,
Yes.
CRLMC 395. My lord, CRLMC 390.
Fresh CRMC matter, your lordship.
1 minute, the online things I'll see. Yes, yes, sir.
My lord, CRLMC 393 of 2325.
Give a memo. We'll see. Give a memo.
Again listed, my lord.
Do you have anybody in the court today?
Yes, my lord, my associate is there.
You send a memo. We'll see. Yes.
Okay, my lord.
So it is a fresh CRMC matter, your lordship. The IO has seized the account of the account has been seized by the IO.
Oh, account is okay. Give.
Your lordship, kindly list this matter tomorrow, your lordship.
Why account is what is the great urgency? People are languishing in jail. Your account is seized. How does it make difference?
Your lordship, he has illegal
Overnight,
seized the
midnight, 12 o'clock night, I'll hear you. What is this? Account is seized. What is this so pressing urgency? You can wait for a few days. Huh? Yes. Yes.
Can you mention from list? Item 1 to 7. Item 1.
My lord, item 6, adjournment.
Somebody saying one.
Item 1. And item 1.
Why these matters are listed and why these people are asking adjournment? I don't know. Huh? Is there anything survives in this matter? Mostly what happens is you file false petitions, complete frivolous petition when the matters are not listed. When I'm trying to get it listed and you come and ask for adjournment. That's what I've seen. These matters are pending, not even listed once. I endeavored to get it listed so that in 24, whatever criminal miscellaneous petitions are filed, all the matters are listed. That's the endeavor of mine. And once it is, tomorrow it is over, all 24 matters. 2024, whatever 482 petitions are filed, all the matters are listed once. And you are asking for adjournment. That means there is nothing in this matter.
Next week,
I will not come according to you. All these matters will go to June. All the matters, those who are asking fresh matters, June.
My lord, item 6, adjournment, brings time.
Yes, June. After vacation, huh? Summer vacation. After
I don't know, 4 and 5 is going to take up next week.
not next week. If you are asking adjournment, all the matters, fresh matter, if you are asking for adjournment, it will go beyond summer vacation. Before that, there is no question of accommodation. All summer after summer vacation. You want to take the risk, take the risk.
Item 7, we have filed the withdrawal memo.
Withdrawal? Yes.
Item 8 to 22.
My lord, item 13, my lord.
13.
My lord.
Same.
My lord, item number 11.
July, huh? July. So
My lord, item number 11.
Let's see item number 10.
10. 10 also. Let's see. Everybody is asking adjournment.
Item number 20.
All these petitions are frivolous petitions. This is 100% sure. All these petitions are frivolous. Yes.
Item 22, your lordship.
22. Yes, 22.
Item 23 to 38.
Item 27. I have to file some more
There is a-
documents.
If any matter is listed, I am getting it adjourned. If before the urgent date, if it is listed, then somebody will lose the job. I must tell you. I am adjourning the matter and they manage it and list it immediately. I have found some matter. Once it is listed, it is adjourned, it is adjourned. Okay. If they manage somewhere and get it listed, I have seen then somebody is going to lose the job. Take it from me and tell the reason.
Yes.
Once I adjourn the matter, means it will come in the urgent date only. Today they ask for adjournment. I adjourn it to May, and they manage and list it after 1 week. What is this going on? There should be some discipline.
If the date will be fixed, that the candidate will.
What is happening is, if I adjourn it to some day, suppose May and all, today they avoid it, and after few days again this matter appears in the list. I don't know how it is comes. All these things are being done. So therefore, I'm just warning them. Once I find, then I'll see it. And if matter is listed, you argue. If there is any material, I'll give relief, or otherwise I'll ask, I'll accommodate you. Yes.
Item 27, I have to file some documents. Therefore, I need some days, not for adjournment. If that
What
is
document
costing
you
of
want
the
to file?
Cognizance,
What document?
that relevant he was absent. That is a mob.
What are you asking here?
Some days, 10 days for adjournment. I have to file some documents.
See, the cognizance order is
Yes,
challenged,
that-
only FIR is filed.
If says charge sheet or ketara jinso rahichi.
Okay, let it counsel for the
10 days.
petitioner seeks to place on record the copy of the charge sheet.
Yes.
As he has assailed the order of cognizance.
Because I am not satisfied with this.
Order of cognizance. 1 week time is granted, release the matter.
Item 34.
38.
So who is proceeding on that?
Item 34, let's
On the request of the balance of
item 34, let's.
34?
34.
Yes,
The can be taken out after.
34, yes. What do you want, madam?
But
Same
taken out
request.
after 1 week.
Not 1 week. I have told you what happened after vacation, summer vacation.
Item 37 also.
37 also. Why have you filed? What is the cause of adjournment? It's not.
Compromise is going on.
Huh?
130 and act. Compromise is going on.
Then argue, I will send it to mediation. Why are you asking for adjournment?
Whether notice has already gone.
Then you tell me, I'll send it to mediation and finish it up. I'll adjourn it, will go to July.
Mediation is going on in the district mediation center.
Then make that statement, I'll accommodate when the date is fixed there.
And another case is there, madam. Same petitioner. That informant is same. 2 checks have been bounced. So in that case, mediation is going on.
Then I'll record it and Land Counsel for the petitioner submits that in the connected matter, the district court has referred it to mediation, and mediation is fixed on.
Okay, I'll take it.
Mediation is going on. Mediation is going on, and she seeks accommodation. Release the matter. Mediation.
Okay.
Yes.
39 to 51,
Yes, sir. Anybody?
52 to 60, 61 to 68. Item 63.
60?
63.
Yes.
Notice has gone to the opposite party.
Notice to the opposite party returned undelivered with endorsement addressee always absent. Bid time. What is this? What are you asking here? What are you asking in this petition?
Question of cognizance.
Cognizance. Then let the opposite party number 2 be served through the IAS. Service on the opposite party number 2 is not complete, as the addressee, as the postal endorsement indicates that the addressee always absent, and the absent. Serve the opposite party number 2 through the IICF also. Since mediation has already been filed, matter to be heard, leave them from. Okay.
Item 68. This is
68.
68 matter, compromise matter. Both sides have come. Can you take up?
12 o'clock? 2 o'clock?
2 o'clock.
2 o'clock. Okay. Yes.
69 to 71. 72 to 80. My lord, item 76 seeking for adjournment, my lord.
76. Yes. What do you want?
Adjournment, my lord.
Why?
My
You
lord,
don't
my
have-
senior is going through a surgery, my lord.
Stay is there.
Yes, sir.
Interim stay.
Thank you.
Interim stay is there, therefore.
No, my
It
lord.
after 2 weeks.
My senior is going through a surgery, my lord. I have also given accommodation.
Sorry?
My senior is going through a surgery.
Okay.
So,
And counsel for the petitioner submits that the counsel appearing for the petitioner on behalf of Mr. Sankar Mishra,
my-
it is submitted that the counsel for the counsel, Mr. Mishra is under treatment, hence an accommodation is served. Please the matter on so. If you want to continue, please. Yes.
81 to 88.
My lord, item number 87. I have some personal, my uncle is seriously is admitted in the
On the
ICU.
personal ground, Mr. Acharya, land counsel for the petitioner submits that there is a medical agency in his family, hence accommodation leave the matter after.
My lord, I request your lordship not to list in between 20 to 28 because 20 to 28 I will be absent. So after 28, your lordship.
Okay, April 1st, week, April 1st, week,
Yes.
yes.
Obliged.
Item number 86, claim for
86.
Yes, sir.
What do you want, sir?
Adjournment.
Adjournment
My
of it.
Interim order may be continued.
Okay.
The adjourned counsel is not well today. He instructed me over telephone.
Who is arguing counsel?
Worship Satyajit Mahapatra.
Okay. On behalf of Satyajit Mahapatra, land counsel for the petitioner, a request is made for an adjournment on the ground that he is indisposed. Lease the matter. Second week, third week, April. Yes. Yes.
89 to 93.
James. Item number 477, 2010. Appeal case stay ରହିଛି respond କରୁନାହାନ୍ତି advocate reopen କରିବା
ଆପଣଙ୍କର appeal
Sir.
ଆପଣ ଫାଇଲ କରିଛନ୍ତି
Sir.
କଣ ଚାହୁଁଛନ୍ତି ହିୟରିଂ ପାଇଁ you are
Sir,
appearing
No, sir. Sir, ୟାଙ୍କର advocate ଯିଏ ଥିଲେ ସେ ସାର୍ କିଛି ଏପର୍ଯ୍ୟନ୍ତ ରେସ୍ପଣ୍ଡ କରୁନାହାନ୍ତି 2010 ରୁ ଫାଇଲିଂ ହେଇଛି ସେ
କିଏ
in the
ଆପଣଙ୍କର advocate
advocate ଚାମଲି ରାଉତ
ଆପଣ ଯାଇକି ମିଶନ୍ତୁ କଥା ହନ୍ତୁ ଯଦି ଆପଣ ନାହିଁ ଅନ୍ୟ advocate କୁ engage କରନ୍ତୁ
ସାର୍ ସେଇଟା ସେ ଚାହୁଁଛନ୍ତି କିନ୍ତୁ ସାର୍ ସେ ଦେବା ପାଇଁ ନାରାଜ ହଉଛନ୍ତି ପାୱାର ଆଉ ସବୁ
କିଏ ନେବା ପାଇଁ
ପାୱାର ଦେବା ପାଇଁ ସାର୍ ନାରାଜ ହଉଛନ୍ତି ଆଉ
ତାହେଲେ କଣ କରୁଛୁ he has lost the trust and lawyers then what can it be done ଆପଣ ନିଜେ ଆର୍ଗୁ କରିବେ ଆପଣ ନିଜେ ଆର୍ଗୁ କରିବେ
ଆପଣ
କହୁନାହାନ୍ତି କଣ କୁହନ୍ତୁ
ମୁଁ ନିଜେ କରିବି
ନିଜେ କରିବେ
Sir.
ନା ଆଉ କ୍ରିମିନାଲ ଏପିଲ ଆପଣ ଟେକ୍ନିକାଲ ଜିନିଷ ଆପଣ କରିପାରିବେନି କାହାକୁ ଏଙ୍ଗେଜ କରନ୍ତୁ ଆପଣଙ୍କୁ କିଏ ଓକିଲ ଦରକାର ଆମ କୋର୍ଟ ତରଫରୁ Lease the matter tomorrow, I'll just. କାଲି ପାଇଁ ମୁଁ ଲଗାଉଛି ଦେଖିବା ଠିକ ଅଛି I'll engage someone on his behalf. Criminal lease it tomorrow. କାଲି ଆପଣ କେସ୍ ଲଗାଉଛି ମୁଁ ଆପଣ ଆସନ୍ତୁ ଠିକ ଅଛି
Item 2.
ଆପଣ ଯଦି ଆପଣ କୌଣସି ଓକିଲକୁ ଏଙ୍ଗେଜ କରିବେ କରନ୍ତୁ ଓକିଲ ଆସିବେ ତାପରେ ମୁଁ ଫିକ୍ସ କରିବି ହିୟରିଂ ପାଇଁ ଯଦି ଆପଣ ଓକିଲ କରିପାରିବେନି ଆପଣ ଯଦି ଚାହୁଁଛନ୍ତି ସରକାରୀ ଓକିଲ କରିବାର ଅଛି ମୁଁ ସରକାରୀ ଓକିଲ ଆପଏଣ୍ଟ କରିବି କାଲି ଠିକ ଅଛି ଓକେ just Mr. Mishra just why don't you see that ଆପଣ ଯାଆନ୍ତୁ ଆଜ୍ଞା ପାଖକୁ କାଲି ମୁଁ ଆପଏଣ୍ଟ କରିବି ମିଶ୍ର ସାର୍ଙ୍କୁ you also assist Mr. Mishra because he is very busy counsel ठीक है you assist just see we can help him out ଆପଣ ଆଜ୍ଞାଙ୍କର ନମ୍ବର ନିଅନ୍ତୁ ମିଶନ୍ତୁ କାଲି ମୁଁ ଲଗିଲା କାଲି କୋର୍ଟରେ ଲାଗିଲା ପରେ ମୁଁ ଆଜ୍ଞାଙ୍କୁ ଆପଏଣ୍ଟ କରିବି ଆପଣଙ୍କ ପାଇଁ ସିଏ କରିବେ ଠିକ ଅଛି just give your number and he will brief you okay yes sir
Item 2.
Page 12 is the order included. Order passed in execution proceedings before your lordship. In fact, during interim order, your lordship directed me to make payment regularly. I have been paying. That is another issue. But question is, Lord, issue before your lordship is, Lord, whether execution proceeding is an independent proceeding or not, whether notice is to be required to be issued in that
There
proceeding.
is an independent proceeding.
Like
As simple as that.
Your Lordship may kindly come to page 12, paragraph 1. How this notice was, my Lord, made sufficient. Your Lordship got it, my Lord?
No, where is that? Sorry.
Page 12, paragraph
Page
1.
base.
12.
Okay. Is 125 proceeding?
In fact, 125, section 23 of Domestic Violence Act. But your Lordship is correct. The procedure is 125 proceeding. This order arises out of execution petition dated.
You are reading where?
Page 12, paragraph 1.
12. Okay.
This order arises out of the execution petition dated 18/2024 filed by the petitioner number 1 Gitanjali Sahu on behalf of herself and her minor son, petition number 2, for realization of area maintenance amounting from OP named Jagannath Mishra, petitioner.
Yes, sir.
For the period from so and so per month, total amounting to 4,73,000, and to direct OP to pay the said area maintenance amount to the petition number 1.
You have been set ex parte.
Your Lordship, kindly, that is the cause.
I have seen it. The
Yes.
copy was supplied to the council
Counsel.
and you did not appear.
Counsel
So
was
I
appearing in the original proceeding.
But see, you all right. Everything
How
is
can
applied.
counsel file Bhakalatum unless that notice is issued to?
I
that is the
understand
crux.
it. I understand it, but it is a very hyper technical and maintenance petition. Why don't you
No,
second?
my lord, I am not on that. Your Lordship may kindly.
You may be correct. You may be correct. But generally, practically, what happens? The execution and petitions are filed in the same court. It is a continuation kind of thing. They take it. It is numbered otherwise.
On he, sir, to file appeal, he has taken back the brief from the council. This is the fact here. Just to apprise your Lordship, this is not, should not be.
So what do you want now?
Your Lordship may kindly allow me to contest this
Yes, madam.
execution procedure. Other I move expert agency. No notice was ever served on
He
me.
has contested the main proceeding.
Main proceeding contested.
Yes.
In the execution proceeding, you want to participate. See, execution proceeding, the main matter, there is an order. You are not questioning. Why don't you pay?
কথা হচ্ছে এখানে একটা substantial amount payment ହେଇଯାଇଛି ସେଇ ଯୋଉ ଜିନିଷଟା ଏଠିକି ଆସିଲାନି
No,
report.
my lord. The, as per objection I have filed.
What is the area you tell me?
Yes.
What is the
Area is more than 6 lakh. 6 lakh.
according to you?
38,000.
According to you?
My instruction is that more than 1.5 lakh have been paid.
No, no.
1 minute. I'll sort
No
out.
instruction.
I'll sort
I
out.
can
See,
file it
you
up.
say 6 lakhs. He says 1 lakh, 1 lakh something is paid.
No instruction.
Instruction. I will take it that 2 lakh you have paid. Okay. Deposit 4 lakhs. I'll set aside and send you. Okay.
ସାଙ୍ଗେ ସାଙ୍ଗେ ଦେଇପାରିବ।
Wait, upon jabbe debe.
2 lakh he has not.
A main matter stands. A main order stands.
Sir, I
In
will
any
file
case,
appeal to that.
I am taking it as if you have paid 2 lakh. I am not adjudicating. I am only saying that deposit 4 lakh. I'll set aside. Go and contest the execution. As simple as that.
Your Lordship may then will not make it will not move କୋକାଲ ନ ତ ଦେଲା ଭଳିଆ ମତେ ଲାଗୁନି।
These installment deposit 2 lakhs and pay 2 lakhs
ସେଟା
for
ନ
that.
ପଚାରି କହିପାରିବିନି।
Huh?
ସେଟା ନ ପଚାରି ସାର୍ instruction
Then that is the best thing I think you
Then
have.
will not, what will happen?
You say that 1.5 lakhs I have given.
No,
According to him,
no.
6 lakhs.
When
6
I
lakh
filed
38,000.
Okay, pay 3 lakhs. I'll set aside and go. Pay 3 lakhs. Take 3 lakhs. Juda miluchi niyantu.
ତାକୁ ଆଉ କଣ ଦେବି ସାର୍ ଆଉ execution ର କଣ ରହିବ he will take 3 lakhs.
You
ଯଦି
say
court
that-
custody ରେ ରହିବ then
What is the area according to you?
at the time of filing my lord ସେତେବେଳେ ବୋଧେ 1.3 ଥିଲା ସେ 4.
Tomorrow you come up. What is the exact area according to you? You tell me. There is area. There is no doubt about it.
probably area ର ଅଛି ସେ
କେତେ ଅଛି କୁହନ୍ତି ଆପଣଙ୍କ ହିସାବରେ ଯେତିକି admit କରୁଛନ୍ତି ସେତିକି ଦିଅନ୍ତୁ ବାକି ଗୁଡାକ adjudication ହବ ଯେତିକି ଆପଣଙ୍କର ହିସାବରେ ଅଛି ସେତିକି ତ ଦିଅନ୍ତୁ after all it's maintenance
ନାଇଁ, ନାଇଁ. Can it be taken up after receipt?
ହଁ ଠିକ है pass out ठीक है
He is wrong. He has not paid anything.
it's all right I am trying to find out the way to use should get any something and he'll contest in the execution you get the further yeah, okay
ଆଉ ତୁ କଣ ପଇସା ନେଇଗଲେ
tomorrow
If you lost.
tomorrow you see it sir tomorrow
କାହିଁ ଖାଲି ଇଲେକ୍ସନ କେସ୍ ରିସେସ୍ ପରେ ସେ ଆମେ
Monday.
ମଣ୍ଡେ ର
Monday you come on Monday okay you simply tell what is the area pay this that much money I'll set aside and go and contest okay yes yes 3 item 3 may I play the yes sir
In item number 3, two connected matters have been listed.
Yes.
In one cause of action, two affairs have been lodged. One in CRLMC number 175 of 2025, my lord.
Yes.
If Lordship will come to page number 14 of the
175?
of 2025, my lord.
Yes.
Page number 14. The affair contents, my lord. On dated 23/12/2020 at 7:12 p.m. one Debesh Kumar Upadhyay, aged about so and so, Housing Board Colony, BBSR, appeared at PS and reported that on night 22nd December at about 8:30 p.m. he was celebrating his birthday with his 10 to 12 friends at Middletown Hotels Bar. Around 10:30 p.m. few of his old friends, that is
So,
my lord,
arrived.
started to quarrel
Missing.
with them and started hitting the rest people. The complainant and Swatam Naik got hit badly. In the above mentioned four people, they also gave him life sentence, so reported the PS.
They came to wish the birthday this thing and they started beating you. That's the birthday gift or what?
No, my lord. I am accused here.
That's the allegation.
Yes, my lord.
You were celebrating the birthday. They arrived.
They have arrived.
They are your friends.
Yes, my lord.
They beaten you up.
The allegation is regards to friends only, and one is affair, and in the other.
What are the 323 and all?
My lord.
And you should notice the young boy.
307 is also there in
Another cell in
The
307.
first one 307. 307. What are the injuries there?
Injury is nothing. No
Nothing.
injury was there.
Notice.
I'll issue notice. Bring them, would see.
My lord.
Bring.
IA has been filed.
What is the stage?
Cognizance order has been challenged, my lord.
1 minute. What is the ages of the 32?
My lord, Annexure 3.
Why have you included the inspector in charge, everybody?
Simple notice may issued to the.
Simply issue notice. You are unnecessarily complicated.
Well, at least 175 the cognizance order is challenged. So
Okay, we'll see.
yes, ma'am.
Sorted the first week, second week, file the process.
Yes, ma'am.
Huh? Yes.
Deployed.
Date by we put some notice. Yes.
Item 8.
May it please your lordship.
Yes, sir.
Lordship, may kindly turn to page 9. Page 9.
What is the last order? Let us see. Pursuant to the order.
Last order is the inspect. That chapter is over, your lordship.
Okay.
Already excused him.
Yes.
Sir, just a minute. I have filed a petition to be intervener in the matter.
In this matter.
My lord, I am suggesting one thing before.
Who are you?
I am the son of the deceased. I filed the petition for free and fair investigation. On basis of my petition, this court passed an order directing to investigate the matter in a particular way.
ମୁଁ କହିବି ସେ ସବୁ କହିବି ମୁଁ ଆପଣଟା ଲୁଚେଇବି ନାହିଁ
He is suggesting something.
It is not so urgent. I am suggesting why my friend filed the petition on behalf of the wife of the deceased for a speedy trial. ମୁଁ ଖାଲି ଦେଖିବି ମୁଁ କନସିଡର ବି କରିବି ତାଙ୍କ କଥା କିଛି ନାହିଁ ମତେ ଖାଲି କପିଟା ଦେଇଦେବେ ମୁଁ ଦେଖି ଦେଇକି କନସିଡର କରିବି
ସବୁ ଜାଣିଛନ୍ତି ଆଜ୍ଞା ସବୁ ଜାଣିଛନ୍ତି
ସବୁ ଜାଣିଛନ୍ତି କପି ନାହିଁ ତମ ପାଖରେ
ଅସୁବିଧା
କପିଟା ଦିଅନ୍ତୁ
ଆଜ୍ଞା 3 ମାସ ଆଗରୁ ପରେ ଫାଇଲ କଲେଣି
It's next week. Give it. I'll put it. I'll tell you. I'll put it up.
ମୋର କଥା ଶୁଣନ୍ତୁ ଅର୍ଡର ହେଇଥିଲା 27/9/23 ରେ ଫର ଫର୍ଦର ଇନକ୍ୱାରି 23 ରୁ ଆଜି ପର୍ଯ୍ୟନ୍ତ 25 ପର୍ଯ୍ୟନ୍ତ କଲେ ନାହିଁ ଏବେ by virtue of the order of this honorable court when this matter was brought by me the police has already filed a charge sheet again with ifs and buts so that trial will continue forever. That is the problem.
So therefore, we'll settle the dispute for all times to come. Let us see. I'll put it on 20th. You give a copy.
Why not on
You tell me when
17th?
17th will be very heavy. Unnecessary will wait. Keep it in the next 24th.
20th.
20th.
Sir,
Give a copy.
will you provide me a copy of the
ଆପଣ ଜୁନିୟର କୁ କୁହନ୍ତୁ ମୁଁ ଗୋଟେ କପିଟେ ନେଇଯିବେ
ଆଜ୍ଞା
କିଏ ସେ ତ ଆପଣଙ୍କୁ ତ ଦେବାର ଦରକାର ନାହିଁ।
ନାଇଁ ମତେ
ଦେଇପାରିବି ନାହିଁ ଆପଣଙ୍କୁ ମୁଁ କଣ ଦେଇପାରିବି ସିନିୟର ଆଡଭୋକେଟ।
But for the ends of justice, now the trial is to be completed, particular period.
Trial long completed.
Matter of
Your Lordship may just see this.
trial has started, na?
No. After completion of trial, the PP had submitted a memo of closure. More underline করছি second, third para. Underline করছি second para.
Yes, I've seen.
Additional PP has filed a memo of closure,
Of evidence.
my lord. And it is continuing. And the petitioner is the wife of the husband, the deceased. She wants that it should be concluded earliest because once it is again delayed, your Lordship knows there is likelihood of bail being granted to the on the question of
They are
delay.
in custody.
Yes, they are in custody. Once they are released on bail, God knows whether they will be convicted.
I am suggesting on that day, Your Honor will hear what will be the appropriate order, Your Lordship will pass it. आपत्ति नहीं, मोर भी स्पीडी है यार, मोर भी लाभ हो चाहिए।
ମୁଁ ଜାଣୁଛି ଯେ ସେଇଠି
Then ଆପଣ concentrate କରିଦେବି
ଆଜ୍ଞା
concentrate କରିଦେବି।
ନାଇଁ ଆଜି ମୁଁ ଆଉ ଦେଖେ କଣ ପାଇଁ ପିଟିସନ ଟା ଫାଇଲ what is the background behind it I must know.
All right, 20th.
ଠିକ ଅଛି 20
20
ଇଏ ଆପଣ କାହାକୁ କୁହନ୍ତୁ ନେଇଯିବ
Petitioner challenged the order dated 18/4/2024
Yes.
passed by the learned court below, rejecting the 3111 petition for recalling the witness
Accused persons are absent.
at Annexure 1. Kindly come to Annexure 1, page 11.
You want to recall PW1?
PW1, informal.
Page 11.
11?
2 times he has been examined. In the last para.
Yes.
Bottom.
Perusal of the record found that on certain PW1 examined cross-examined defense. Thereafter, recall petition so and witness further examined so and so. After the examination of all the prosecution witness record was protected argument and the state and the counsel of defense counsel cross-examined PW who has already been cross-examined 2 times. Yes. What is the reason? You can't keep on calling.
Last part, my lord.
Yes.
This is a case under section 302 IPC. But my case is 306, 406 and 498.
Whatever, but the PW1 appeared before the court twice. At your instance, 311 application was moved, which was allowed. He came. And third time again you are moving application.
No, thereafter the contrary counsel in change.
Oh, the counsel change will not keep on. Then you change another counsel, 1311.
No, my lord.
This is not the ground. You have to be fair enough.
Some
And mayor change, where is the ground you have given?
ground, my lord, page 22.
Yes. Show me ground.
Point 5, last part. To know the scribe of the settlement under Exhibit 1, place, date and its subject of the said settlement.
Where are you reading?
Item, no, page 22, my lord.
Para, tell me.
Last
paragraph?
Last sentence.
No.
To know the scribe the settlement under Exhibit 1, place, date and its subject.
No,
of
these are not.
settlement. This was the
There are scope to.
the FR
You need defense evidence.
only FR was not described.
It's all right, but why have you not asked? Where is the explanation? 311.
But deposition, she said.
Where is the explanation in the second time when you called and using 311? Why have you not put this question? Where is the explanation?
Yes.
In the entire application, show me one sentence.
No.
You can't mechanically keep on asking one witness. You change the counsel and he is a wiser counsel and he'll call.
Change of lawyer also.
No, not at the ground.
Change of lawyers cannot be the grounds for 311.
Then there is no end. You
This is
can
the
keep on
province of
changing
justice.
law.
That he could not put that question down.
As per
Another
the
I will
contradiction
give you that liberty to lead the defense evidence in that regard in whatever manner. Right. Petitioner is agreed by the order dated 18/4/2024 passed by learned sessions judge additional sessions judge Anandpur in ST case number 12/39 of 2017, dash 2014, whereby the application moved by the petitioner under section 311 CRPC for recalling PW1 has been turned down. The perusal of the impugn order reveals that the said witness was initially examined on 7/8/2018, and he suffered extensive cross-examination by the defense. Subsequent thereto, petitioner moved an application under section 311 CRPC for recalling the same witness for further examination. The application was allowed, and the said witness, namely PW1, was further suffered cross-examination on 9/11/2020. After the closure of the prosecution evidence, when the matter is at the fake end of the trial, at the conclusion of the trial, the petitioner moved another application seeking recall of the said witness, that is PW1. Therefore, the trial court has rightly turned down the application inter alia, observing as under page 11, last para, on perusal of the record. There is no legal infirmity. I have also perused the application moved by the petitioner under section 311 impugn application moved by the petitioner under 311 CRPC. In the application, there is not a single whisper explaining as to why the witness was not put the questions sought to be put to him now. The only explanation that counsel for the petitioner submits that there is a change of counsel, and new counsel, new defense counsel has moved this application. Change of counsel by the defense is not a substantial ground for moving the repeated application under section 311 CRPC. Hence, I'm not finding any legal infirmity with the impugn order. I am not inclined to entertain this petition. Accordingly, same is dismissal. However, dismissal of the present petition shall not preclude the petitioner to lead defense evidence in that regard. With this observation, the petition is disposed of. Yes, next. Yes. Yes. Yes.
This case, petitioners filed for a direction for investigation of the matter.
Sorry, sir. Proper investigation.
It is a accident case, minor. In the morning hour, accident took place, and 3 PM FIR lodged. Everything in the FIR and
Who are you? Who are you?
I am for the wife of the deceased.
Okay.
Minor, the police, after all the confirmation, has completed the case with the
FIR abated.
Abated consideration.
Thereafter, the 1/6 case is filed. The non-HDCM, JMH is already directed to the IAC to make a proper investigation and inquiry. That order is fine place.
That has not been carried out.
Okay, where is that?
That 35, your lordship, can glance for a moment.
35.
Yes, your lordship.
Yes. Yes. Where is that? The complaint personally filed the
2/3/2020, your lordship. That order.
Against in favor of the complaint to be verified and accepted, registered the original complaint concern, giving you the gravity and the nature of the problem. When the original complaint is to IAC concern, and the IAC concern, counsel is directed to treat the criminal fire along with the 156 submit the report. What do you want?
That order.
The order was passed on 2/3/2020.
Yes, sir.
Nothing has.
No, my lord. 4 times I have given the copy.
Yes.
My respectful submission also, if against the inaction, my learning senior can approach under section 227, to CRL MP or also.
Just forget
That-
about
That's
this.
right, I'm not.
Why, don't try to be
Instruction, Lord.
servant up for the
Next week,
procedure.
you'll also let it come.
Come
next
to the main
week.
point.
Yes, that's right.
2020, the order was passed.
That's right.
What
Your
are you
Lordship.
doing? Simple.
Next week, your lordship can let it.
Ask him to go into 27 route
Yes, sir.
revision and all. You just don't tell all this procedural thing. Come
sir.
to the main point.
Yes, that's right. Your lordship 2020 orders in past. I lordship let it come next week.
Ah,
I'll obtain instruction. and
List
make
it on
that.
24. Get instructed.
Yes, lordship. Positively.
There's some exigent case
That's
that
right.
they
I'm very.
order. Why they are not doing? Who is
Unfortunately.
police station is this?
Dharmasala Para.
Dharamsala police station. Huh?
Yes.
The land council for the petitioner is agreed by the inaction on the part of the IIC Dharamsala PS on the annexation of so pursuant to the order dated 2/3/2020 passed by the JMFC.
24.
JMFC in
24.
1 CC case number 66 of 2020. Let Counsel of the petitioner submits that despite a specific direction by the JMFC to register the FIR and complete the investigation, even after lapse of more than 4 years, nothing has been done as yet. 5 years. So 5 years, nothing has been done as yet. Issue notice and the IIC Dharamsala to submit a report, action taken report by 24th of this month without pay.
A copy of the order, lordship, kindly. Free copy of the order of this.
Without pay. Huh?
Yes, sir.
You give it and
Yes, I'll
reply.
today I will.
Yes. If you ask him to file 227, he will withdraw. He file another petition.
That's right.
Another court is engaged for this.
It's
You
unfortunate.
tell what has
Very
happened, finish. Unnecessary. Yes. Yes, sir.
Petitioner claims for quashing of a criminal proceeding in view of the compromise between the parties.
Yes. Compromise. What are the offenses?
Offense under the offense under section 376,
376.
6 POSCO is also there. And
Issue notice, let us see.
petition.
Issue notice. Issue notice.
Date may be fixed, so
Date
that
will be fixed. April 2nd week date fixed.
so the informant as well as the
Yes.
victim.
You have already implemented. Huh?
Madam.
Yeah, pleaded, take out notice, Mr. Mahanti accept notice for today and read the judgment which I have passed.
Stay off, NBW. Yes.
Enroll petitioner 1 to absconder thila, tar enroll on the prayer of the IO. Enroll 11 issued. 2, 3 using their parents.
Matter as well.
One day, they are married or what? What is the terms of settlement? What is the terms of settlement?
Settlement matter as already amicable.
I understand what is the terms, whether he is married to the girl or what?
She has got married to the another person.
Who?
The victim.
Victim is married. Where have you said that?
Informant.
Then I will not say that. You should have said that she is married anything. He is absconder. Why should he be protected? Yes. Next.
Shorted maybe. Till then.
Next.
Yeah.
Saying for you withdraw, my lord.
You want to withdraw, madam? Yes. Yes.
May I please your lordship? When 490A was inserted in the penal code, I thought that it is a instrument, can be said that it is atomic energy. But that was used as an atomic bomb. Your lordship, what happened? The opposite party, number 2, is a judicial officer. Her husband died. Thereafter, she came forward with an allegation that the in-laws are not returning her articles.
Then you say that judicial officer is atomic bombs.
Yes, I can say. My purpose of filing this application is that I should. He should.
Fact of the matter is a matrimonial dispute. And
Yes, that will be materialized in the mediation center High Court. I will return all the articles if at all she is entitled to get. But using the police agency by filing a pair, the police people, they are pressurizing you return all the things. Who there? How the police agency will settle the matter? That is the so.
I'll issue notice and send it to
Yeah,
the
yes.
center.
Yes, ma'am.
And stay the proceeding. She is
That
a
will
neutral
solve
officer,
the
unless
problem.
it's required. Madam, issue notice to opposite party number 2. Mr. A dispute is arising out of a matrimonial discord. Therefore, I feel it appropriate to refer the matter to High Court Mediation Center for exploring the possibility of a settlement. The coordinator of the mediation center shall fix a date and intimate to all the stakeholders, and after exploring the possibility of settlement, file a report before this court. Awaiting the mediation report, please the matter on so and so. In the meantime, proceedings before so and so is stayed.
For quashing of affair on the grounds case and counter case.
Case and counter case. What are the offences?
So 296, 351, 2 under 115, 2 190 BNSL also.
No, what are the allegations?
Allegation is that there is the large civil dispute. The present petitioner and others family members abuse them to in slang language, and that is page 19 also.
Threatened to assault, no assault.
Yes, that is it.
Oh, thappada maar diya. I'll issue notice.
Petitioner.
Minor allegation.
Yes.
Pullu tultula thappada maar dala.
Again.
Issue notice. Yes.
May I please your lordship? I am
Yes,
calling.
sir.
In this case, my lord, the petitioner has challenged the order of Cognizance dated 31/3/2023 by deleting the name of Dinabandhu Nayak, and the London Court will has not took cognizance for commission of offence under section 341, 323, 325, 326, 307, 506 of the in the name of the opposite party number 2.
Who are you? Who are you? Who are you?
I am the informant.
So show me the charge sheet.
Page 30.
Yes.
To the date of incident occurrence, the Dinabandhu Nath, who is to be implicated as accused, is a juvenile. The date of birth is the lordship 11/3/2024. To the date of occurrence in 17 years, 3 months, 8 days. Therefore, the IO has accept that Dinabandhu Nath implicated and filed the charge sheet. But my learning client has obtained instruction under the RTA Act that in the JJB board, the President Dinabandhu Nath not been implicated, but not case has been initiated against the President Dinabandhu Nath. That is the prayer.
I'll issue notice.
Yes, sir.
Needs to be. Yes, issue notice.
Stay the proceeding. I have to stay the further proceeding.
Why? Whatever cognizance is taken, let it go on. We let if any offense is to be added. Why are you are the complainant? Why are you trying to stall the trial? Don't do that. Let it go on. Yes.
19.
On behalf of Mr. Vijay Kumar Ragada, praying for a short adjournment, Your Lordship.
Why? Where is Mr. Ragada?
He is not here today.
What is this matter? Where is your file?
Here, Your Lordship.
You tell me what are the facts. What are you challenging? What do you want? Just see the prayer, madam. You have been sitting since the morning. You have not read the file. Read it. Adjournment is not by way of right. Court can decline. So therefore, you should be ready. Tell me what. I'll pass or read it and come at 2 o'clock. Let her read. Read it and come. Okay. Adjournment is not by way of right. Suppose you ask the court decline, then what will happen? You must prepare and come.
I'm sorry, Your Lordship.
On behalf of Mr. Raghav, what is your name?
Pragya Elena Das.
Pragya Elena Das has sought an adjournment. He is not well or what?
He's not here for this moment. He's not here, Your Lordship.
Please, first we second week for this. Yes. Yes.
20.
Please, Your Lordship.
Yes, madam.
Your Lordship, we have
Yeah, the present petitioner has already been convicted by this court by a way of revision, Your Lordship. However, yes, Your Lordship, the conviction has been upheld, Your Lordship. However, we have filed a 482, Your Lordship, seeking of quashing of that order because the factum of compromise that had already taken place between the petitioner and the opposite party number 2, that had not been taken into consideration.
What are the offenses?
498.
498, Your Lordship.
Yes. You have settled the dispute.
Yes, Your Lordship, the dispute had already been.
Yes.
May I please? Alert, he has preferred, after conviction, he has preferred an appeal before the.
That is
That
confirmed.
appeal, that judgment has not been annexed here.
No.
Thereafter, they have entered into an agreement in the local adalat, settling the matter between them. Thereafter, the order on 9-10th October, the judgment passed in the criminal revision before this court. Conviction confirmed.
That is what I
Where is that
used.
order? Where is that order?
That is at Annexure 4, Your Lordship, page 46 to 65, by a coordinate bench of this honorable court.
Yes. It is now upheld. Your conviction is upheld.
Convicting the present petitioner, Your Lordship. Revision achi to petitioner.
Yes.
The judgment of the appeal passed by, they let him to annex that appeal.
No, that is annexed, na? Annex
No. Appeal
that
judgment
appeal is
annexed.
not annexed. Appeal is.
Yes.
But the fact of the matter is,
the
fact
the
that
law,
is confirmed here.
issue is, even if the conviction is upheld,
Yes, ma'am.
on the ground of settlement, he can maintain a 482 petition
Yes,
or a writ petition. Because these are the
Whether
offenses,
that
you know.
compromise between the parties has been
Matrixal
taken note of in the appeal, that is to.
Your Lordship, that is what.
Whether in the revision it is taken note of.
Yes.
Yes,
Whereas-
taken
Yes,
note
Your
of.
Lordship. In the
Yes.
Lordship, page 52, Roman 5. Lower appellate court failed to appreciate. That's the fact of our submission. The
No.
petition of
How the revisional court deals with your
Yes, yes.
settlement part.
that is
If the revisional court has dealt, the
yes.
coordinate bench has dealt with your compounding thing,
Yes,
has
Your
not agreed with you that, then perhaps you can't maintain a 482. After the conviction, confirmed by the appellate court, if you enter into a settlement, then you can maintain a writ petition.
That is what is my contention, Your Lordship. Even if Your Lordship calls for the record of that criminal revision, Your Lordship, the certified copy of the deed of
Let us see
compromise.
what the order, where he has dealt with.
Your Lordship, page 52, clause 5 is what my learned
that is the
senior
submission of
says.
the appeal.
No.
That was the submission, Your Lordship, and that has been further dealt.
In para 10.
Para 10. That is submission. How the court deals with it.
That has not been. The factum of compromise has not been dealt with, Your Lordship.
But it is brought to the notice of the court.
Yes.
It was only brought to the notice that.
What is the law on that subject?
Your Lordship, the law as far as I place, Your Lordship, is that once the appellate court, Your Lordship, has given a reasoning that since certified copy of the deed of settlement was not presented before it, that is why on the basis of Xerox copy of a deed of settlement, it cannot hold any order of acquittal, Your Lordship. The same copy was not placed before the coordinate bench of this honorable court, Your Lordship. That is why since 482 be then as it stood by and now also, it is inherent power of this honorable court.
That's
And
there, the writ petition or 482
Yes,
they
Your
can be maintained. But if the question is, if it was brought to the notice of the appellate court as well as the revision court, and they have already dealt with it, then perhaps
Your
you
Lordship,
can't maintain.
yes, Your Lordship, that is
That is-
again is my contention that in the criminal revision of this honorable court, Your Lordship, there is one submission that a local.
But that can only be done by the appellate court. Again, you have to file you have to challenge that order and
Your Lordship,
bring to the notice.
the appellate court did not accept that submission. That is why.
That's right. Therefore, revision court court noticed that,
Revision
but not dealt with it.
has not given any finding to that effect.
But noticed it.
Yeah,
It
yes,
was
Your
noticed
Lordship. Yes, Your
and
Lordship.
not dealt with it.
Yes, Your Lordship.
Then in that scenario, the only remedy for you is to file it in the
Higher.
superior court. Notice SLP.
Your Lordship,
If had it been a case where the conviction is done, thereafter you enter into settlement and you can maintain a writ petition or a 482 petition. See, this is what happened. It is a matrimonial dispute. We have settled after conviction and intervene. Then you have a case. But once it was there earlier, two courts have dealt with it. One court has dealt with it, another court has noticed it but not dealt with. Then you have to go to the third court only. If you have any judgment, you support.
Your Lordship, I have, because I have one judgment of the Punjab and Haryana High Court.
No, Delhi High Court also there is 138 case. There is
138 case, one judgment I've got from Punjab and Haryana High Court, where it says that if a procedural irregularity or a party has not been heard or this factum of compromise has not been brought into before the notice of
That's
the court,
right. Before the
that
notice
would,
of the court.
yes, that would
That's the
prevent
problem.
the abuse of process of law. That is the word, Your Lordship. And here also, Your Lordship, in criminal revision also, the if Your Lordship looks into page 52, exactly it has not been said that the factum of compromise has been entered into. Only the fact that a payment of 50,000 has been made towards the settlement. That is the only submission. That is why.
But the appellate court has noticed it.
Yes, Your Lordship.
And it is obvious the revisional court might have done it.
The revisional court has not
It
given
is
any-
just gloss over. Then in that situation, you can file an SLP only. I can't help it. That's the problem. You have a direct judgment, you give me. I
Your
can
Lordship,
deal with it.
I'll give Your Lordship.
Otherwise, it's very difficult.
What
If
I
you
can.
would have you have entered the settlement after the conviction is upheld, then 482 or jurisdiction or a writ jurisdiction can also be exercised. You will get the direct judgment on Delhi High Court judgment.
Your Lordship, the fact of.
That too in Supreme Court. Thereafter, it was filed and it was entered. Saying that even if Supreme Court has upheld the conviction, if you enter into settlement subsequent thereafter, it can be entered. Delhi High Court judgment, straight away. Cut hold of that. There are some observations made there.
Yes, Your Lordship, I have. I can-
Yes, and simply it then.
21.
But that was 138 case.
Yes, Your Lordship. Your Lordship, in other criminal cases, I have one from Punjab and High Court. I'll get hold of
There
the
is there
Delhi
from
High
this
Court.
subject.
Yes,
It
Your
may
Lordship.
help others also.
Even if Devinder Pal makes it clear that 482 is maintainable in certain cases, that would not amount to altering or reviewing of the judgment of the Honorable High Court, Your Lordship. I'll submit before Your Lordships those judgments.
Let us see. Okay.
My pleasure. This is
Next week,
application.
Your Lordship. Next week, Your Lordship.
First week.
Your Lordship.
This application for 457 released of seized materials.
And
my lord.
Mr. Mishra is nodding his head, just ask him. He must be having some judgment with him. He may help you out. Yes.
This is 457 released of seized materials, my lord.
21.
I am challenging here with the annexure 6, my lord. The appellate that is page 35, annexure 6, my lord.
35?
Yes.
Yes.
Before that, my lord, I draw attention the.
Now, what are you challenging by the way?
Not releasing the seized
Releasing the
materials.
seized articles.
Annexure, kindly say annexure 5, my lord. The finding of the lower court, my lord. For that reason, I draw your attention.
34. Yes.
31.
Which page? 34.
29, page 29.
29. Yes.
Before that, I draw your attention.
Yes.
I filed initially 457 before the JMFC Kemujar, my lord.
Yes.
Kindly see page 31, running page, my lord.
Yes.
Because my materials have been seized.
And
He sought for, during course of hearing, he sought for call for a report from the IO whether the seized materials has been required or not. That is the, moreover, that is the finding of the lower court. Moreover, in order to ascertain the requirement of the seized manganese ore for the purpose of investigation, this court has issued letter to the concerned IO of this case. To that
Yes.
effect, the
I've seen
concerned
the
IO of this
confiscation
case
proceeding has not been initiated also.
Yes, my lord.
Yes.
Not required, and the investigation purpose, and this, and the finding is also.
And even confiscation proceeding is not initiated.
this is the finding of the IO,
Yes.
and so this the said material
Yes,
is
yes,
mine.
come to the revision. court.
I am done.
Yes.
Rejection is the lower court, my lord. Send materials to sample materials not tally with the seized materials. But that is the reason, and that is all confirmed in the
Said material may not be an ore,
base.
but it is an
So
alloy.
what he is written in the seized day, so I pray the seized materials as per the seizure list we may release down. So it is open. So now not required. And when the finding is
What the revision court says?
Milord?
Revisional court.
Since confirmed,
Where is
so
that?
that is not tally, so
Oh, why don't you keep sample and release it?
Yes.
The entire material which is seized, you need not retain that. You can keep homogeneous sample and release it.
stock was also released on.
I'll take instruction.
I'll issue notice. See,
Yes.
but this can't be a ground. See, you have not initiated a confiscation proceeding.
Yes.
Your IO says that this is not required at all.
Right.
And now the court rejects it, saying that there is a doubt because it is not the same
ore and alloy.
alloy. So you can take a homogeneous sample and keep it, and the rest of the thing and release it with condition.
Yes.
As simple as that. Issue notice.
Only of state is the party only.
Yes. Next. 23.
Short date may fix.
Short date, second week. Yes.
May I please, my lord?
Yes.
And the crux of the matter is this, my lord. The learned STGM has Sonpur has taken cognizance, and the learned STGM Sonpur has lacks jurisdiction. My kindly have gas annexure 3 page 61.
61.
61.
Yes.
This is a case under section Drugs Act, Drugs and Gun, and Drugs and Customs Act Sonpur provided with district and sessions of Sambalpur. Madam, page 61, my lord.
Yes.
Whereas the drugs and customs and so on.
Where are you reading?
My lord, page 61.
61.
Notification.
Yes.
Notification.
Yes.
Second para. And whereas one of the provisions of the drugs and customs and to them relates to constitution of special designated courts for trial of offences relating to adulterated or spurious drugs, wherein it has been provided that the central government or state government in consultation with the Honorable Chief Justice of the High Court shall for trial of offences relating to adulterated drugs or spurious drugs by notification designate one or more courts or sessions as a special court or special courts for such area or areas are for such case or class or group of cases as may be specified in the notification. And whereas it is found that by the end of the various drug cases numbering 381 are pending with different courts of law in the state and the expect trial of such a needs creation of special court. Now therefore the state government after careful consideration of the matter of subsection 2 that of drugs and customs and so and in concert with the Honorable Chief Justice of High Court of Orissa have been pleased to designate the following courts as mentioned in column 2 of the schedule as the special courts for trial of offences relating to adult drugs or spurious drugs punishable under the special 36 AB for special.
No. What do you want to say then?
My lord, this case, STGM Sonpur has no jurisdiction. Man, page 62. For a Subhanpur.
Where is that?
Subhanpur, page 62.
Yes.
Serial number 3.
3, yes.
District and sessions.
Sambalpur.
Sambalpur. The case will try. Balangir, Subhanpur, Sambalpur, Bargarh, Jharsuguda, Devagad and Sudargarh.
For the purpose of trial.
For the purpose
of by a notification, the High Court has decided for the purpose of trial, these are the designated court. So it will be transferred.
The case should be transferred.
It will be transferred.
No,
Why do you?
Till today.
How do you say that cognizance is wrong?
And the lack of jurisdiction.
What jurisdiction?
So
in the notification, it says that it will be tried by a particular court. And on the basis of notification, jurisdictions are bestowed on the courts. Can the notification by way of notification by the administrative side of the High Court, jurisdiction of some court is taken away? It is for the convenience. It is said that that particular court will try. It will be transferred. Move an application, it will be transferred and it says it is only says for the trial. For the purpose of trial. Now cognizance is taken. It will be transferred. Go and move application. How can you challenge Cognizance order saying
Madam,
that?
observe that will transport to Sonpur.
Why should I observe? In a 482 proceeding, why should I
She
do all
could
this?
say in view of the notification
I'll just say that you are withdrawing to apprise the court.
regarding this.
Apprise the court regarding the notification. That's
Notification.
all. Then, the petitioner has challenged the order dated 3/3/2022 passed by 11 CGM Sonpur in 2 CC case number 84 of 4/2021, whereby cognizance of offences punishable under section so-and-so, page 60, so-and-so has been taken against the petitioner, Mr. Pradal and counsel for the petitioner, drawing my attention to the notification dated 6/6/2013 issued by the Government of Orissa Health and Family Welfare Department submits that the trial of the cases for the present nature should have been conducted by the Suvarnapur, SDGM Suvarnapur, as per the notification. I am not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to apprise the notice to the concerned court and seek for appropriate orders. With this observation, petition will be disposed. Yes.
Madam, pardon. Appropriate order may be passed by the STM in view of the notification.
Obviously, that. Yes.
24.
Yes, my lord. Petition filed by the petitioner on the ground of compromise the matter by the accused and informant. My lord. The arising out of love affair occurrence was happened when the
What is the stage?
when they are
What is the stage?
stage, my lord, now charge sheet perhaps filed, my lord.
You decide whether charge sheet is filed or not. You have only filed the copy of FIR. Nothing is there. You have not said what is the stage.
When their love is breaking, FIR lodge, now they are already been compromised and settled and they are good relation now. The informant wants to withdraw the FIR, but ମୁଁ ତାଙ୍କୁ କହିଲି try your luck 482 ରେ ସେମିତି ତ withdraw କରି ନି ପାର ମୁଁ ଗୋଟେ ଫାଇଲ करे କହିଲି I pray before this.
Why are you unnecessarily trying, wasting the court time? You withdraw it if you want. If you can.
Withdraw ହେଇପାରିବ 482 my lord.
It is a case of 376.
When compromise,
withdraw. You file it, withdraw whatever you want to do.
My lord, when compromise matter, your lordship.
I'll issue notice, settle here. But you tell me what is the stage, whether charge sheet is filed or not. Nothing, you have not said anything. Except the FIR, nothing is there. And there is no affidavit also, compromise affidavit.
File kori.
Notice. I am just issuing notice. You file everything. Otherwise, next time it will be dismissed. Okay.
I file. I am.
Yes.
25.
My lord, I have filed a IA petition.
You have not. You file a incomplete petition. I am just giving you indulgence. If you would have said, I don't know what is the stage, investigation. You have not said whether charge sheet is filed or not. If investigation is going on, how can I state?
I will submit.
You must be sure about it.
Yes, I will submit everything.
And which court is pending?
Yes, ma'am.
You don't know.
No,
you know nothing.
File.
Except filing a copy of FIR. How can I stay like this?
No consequence.
If you would have disclosed the case number, where it is pending and all, I could have passed.
Pending, my lord, STGM.
No, but you are not sure whether charge sheet is filed. Some court name you are saying on all these things.
My lord, SDGM no apara.
Give me the charge sheet, show me.
I will submit.
Also, that is better that you do. Nothing is there.
No consequence.
25.
Otherwise,
simply issue notice.
Item 22 is passed.
Prejudice.
May I audible, my lord?
Yes, I can.
Somebody has adjourned 22.
Oh.
Somebody, I don't know, your brother has mentioned.
Anyhow, this Union of India is a copy number 1, formal party or the contesting, I don't know. Only appearance will be noted. Non-appearance will
Okay,
not.
appearance. Mr. Fadi's appearance. Huh? Item 22, huh? 22. Yes.
May I please, ma'am? So the 457 application of the petitioner has been rejected, my lord. He had
What
filed the said petition for release of the cash and the ream.
Cash and?
Ream.
What
the,
ream?
The
ream of truck.
Tire ream. Truck ro ream ta jota.
One ream.
One ream.
What
Of my
what will you do with that ream? You are going to
of
sell
the
it or?
petitioner's vehicle. It has been stolen. The dumper was stolen and it was seized from the.
What is the cash amount?
61,000. Para 2 of the order, page 20, Lordship, may kindly peruse.
For that you filed a revision, you filed so many things. You might have spent more than 61,000 rupees.
And the dream is there, my lord.
How, if you sell, how much you will get in dream? 2,000.
Borough dumper or ream tap.
3,000 of the.
No.
Okay.
Dumper or ream tap.
Kete tanga? Kounanti?
Besi hoga.
Kete hobo? Kounanti? Besi hobo kete? Lokhe thodi hobo? 10,000 tanga hobo au kono? 10,000 tanga hobo?
Car or ream guda aega poduchi 25,000 tanga poduchi.
10,000 tanga hobo. After you are spending more money to get it recover, you file 457 that is rejected and revision petition now is Supreme Court, High Court.
What
is it? Release it. Why unnecessary you are forcing people to come to the court like this?
Yes, madam.
Matter of 61,000. What will you do with that money? He will give indemnity bond. Release it. Shall I issue notice or what? Or pass the order? Pass the order, right? They are small.
Indemnity bond देगी.
Indemnity bond देगी. I don't. Petitioner is agreed by the. Who are you, by the way? You are the.
I am the owner of the vehicle and the informant.
Informant.
Well.
Petitioner is the informant. In PS case number so registered under section 379 against the opposite parties.
Yes.
Private opposite party. Private opposite party. The 379 na private opposite party. The rupees 61 lakh cash. Cash na
61,000.
61,000 cash.
Lordship, may kindly have a glance to page 20. Lordship will be page 20.
Okay. Yes. Yes. The allegation in the FIR is regarding the theft of the dumper bearing number OR -K -2624 along with rupees 61,000 cash. Cash. The petitioner being the informant and the owner for the dumper as well as the cash moved an application under section 457 CRPC before the learned which court is that?
SDGM
Jajpur. The learned SDGM Jajpur by the order dated 5/1/2024 rejected the application. Therefore, the petitioner filed criminal revision number 3 of 2024 before District and Sessions Jajpur. By the impugned order dated 9/8/2024, the said revision petition has been turned down. Inter alia observing agent. Parasel. Mr. Vishal and counsel for the petitioner submits that there is no dispute regarding the recovery of the dumper rim 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 as well as the case from the accused person. He being the undisputed owner of the article moved the application for release of the same, which has been turned down. Mr. Vishal appeals for the date. Opposes the prayer for the petitioner on the ground that there is no legal infirmity in the impugned order. Hence, no interference is called for. called for regarding head to the facts of the present case and the nature of relief claimed by the petitioner. I'm inclined to allow the petition. The trial court is directed to release the cash for rupees 61 lakhs.
61,000.
61,000 and the dumper, rim of the dumper, dumper of the dumper bearing the number OR 09 over so on any condition deemed fit and proper, with this observation, petition is allowed. Yes.
Yes.
26. My permitted. On behalf of Mrs. Ponda, the petitioner is filing this petition for quashing of the FIR at Annexure 1. My lord, the petitioner is accused under 376(2) and POCSO Act. My lord, para 7, I have mentioned that the girl is not rescued from the custody of the petitioner, my lord. So notice may go and informant may appear.
No, investigation is going on.
My lord,
investigation is going on.
Charge sheet is not yet filed.
That's right. Then why should the court will interfere? It is a 376 POCSO and all.
My lord,
merely because the girl is recovered, that can't be a ground.
My lord, I am harassed unnecessarily because I have no fault in this case.
That way, the investigating agency will find out whether fault is there or not.
So no, if a notice go, they will submit.
Unless you make out a case, I can understand if you have settled the dispute, then I can examine that. Merely you are only saying that the girl is recovered. Girl will be recovered only.
My lord, the affair is since 11/1/2024, my lord.
That's right.
My lord.
That's right. Investigation is
The
going on.
petitioner is no involved in the alleged offense. So
that investigating agency will do, because these are very serious offenses.
till then I am facing
Serious offenses. It
unnecessary
can't be like
problem.
this. You withdraw it and come at the right stage. Don't invite any order.
ସେମାନେ ତ କରୁନାହାନ୍ତି for it. ମାନେ ଆପଣ charge sheet file କରୁନାହାନ୍ତି. So honestly, I am being harassed because the bail
That's
court
good
is-
that charge sheet they are not filing. Are you on bail? Anticipatory bail?
No, I am not.
Absconding?
Absconding.
Then how will they file charge sheet?
That's why I
the
am
problem.
before your lordship.
A petitioner is one of the accused in PS case number so and so for alleged investigation in the present case is still going. At this stage, petitioner has challenged the petitioner filed the present petition seeking quashing of the entire FIR on the ground that the victim girl has already been recovered. The ground on the basis of which the present petition is filed is not sustainable or not sustainable because the investigation in the present case is still going on. Therefore, I am not inclined to interfere in this matter. However, the liberty granted to the petitioner to approach this court at the appropriate stage if a cause of action substance to this observation petition it is put. Yes.
28.
Yes. Yes, madam.
28 number. Seeking for a direction to the Lord and below court.
Early disposal of GR case.
Yes. GR case number.
FIR registered on
11 August 2014.
2016 FIR charge sheet.
Charge sheet, yeah.
You are the informant.
No,
No, I am the.
he is the accused.
I am my property is seized by the.
Who are you, madam? Are you the accused or informant? Who are you?
I'm not accused in this case. I have a my property is seized by the.
The problem is you are neither the accused nor the informant. You are asking the case to be expedited disposed of.
Because
What is your locus and you must.
my property, my mortgage property has been seized by this court.
That's it.
That's
Page 44.
44, huh?
Yes.
Yes.
Under the above circumstance, prima facie evidence is well made out against the accused person, Sajan Kumar
What is
Santuka,
his
Basant
name?
Kumar Behera.
Name is Kishori Lal
Kishorilal,
Napoleon.
Chapalia.
yes,
He
ma'am.
has nothing to do with this case.
Now, he is the conspirator in this. His name has been taken in the
No,
paragraph.
where is the charge sheet? Let us see.
Charge sheet here.
Yes, charge sheet.
That
Please
is the
see
charge sheet. Page
Madam, you
40.
must know
It
who are
starts
you,
from
first of
page
all.
40.
40, 40.
40. Brief fact.
Have you filed? the charge
Kishorilal Chapulia of Kotak.
sheet?
It has been alleged that the leasehold property corresponding to so and so land measuring so and so new under Tangi Tauja Tahsil in the district of
minute,
Kotak was registered in the name of Kishorilal Chapulia Kotak. In the above said property has been transferred to the name of Sajan Kumar Santuk. By fraudulent means, by submitting forged documents. Thereafter, next para, investigation revealed that Kishorilal Chapulia had taken one farm on lease basis from OSFC on
But
27.
charge sheet is not filed against him.
Yes.
Charge sheet is filed against Sajan Kumar Santuka and Basant Kumar Behera.
Yes, my lord.
Basant Kumar Behera. Yes.
Before that, your lordship, may I read that the paragraph. So from the page 43, so from the statement witness coupled with the documentary evidence collected so far, it is well established that prima facie case made out against the Sajan Kumar Satya Santuka, transferee and Basant Kumar Behera, dealing assistant, who was dealing with the file.
That's what I'm saying. You have not filed charge sheet against this petitioner.
But just below that.
Yes.
Who have committed criminal conspiracy and have been able to make such fraudulent ROR in favor of Sajan Kumar Santuka by tampering the records and showing the transferors Kishorilal Chapulia absent in the locality of Kotak town, though he was present all along, thereby created Kishorilal Chapulia as well as IDCO authorities by preparing forged document with a view to grab the valuable industry with the land of area so and so.
Yes, I understand.
Cause financial.
Yes, madam. You tell me what locus standi you are.
My lord, I would.
You should be happy that charge sheet is not filed against you.
Yes. ମାନେ ଆମ against charge sheet ହେଇନି ତେଣୁ ଆମ property
But your involvement is there. I don't know why charge sheet is not filed against you. I don't know. You should be happy on that.
No, but in this case, যেহেতু mortgage ଆମେ ଯେହେତୁ property ଟା ଆମ property ଟା ସେମାନେ ମାନେ industry ନାଁରେ
This is not, madam, this is not a property dispute. It's not a property dispute. You have to make out a case. You don't have a case because you have no locus standi. The accused is someone else. Informant is someone else.
Yes.
You are party to that impersonation. Somehow charge sheet is not filed against you. Doesn't mean that you can ask for expeditious disposal. Expeditious disposal can be asked by the accused persons because they have a right of speedy trial. What right do you have in a criminal?
I'm affected because my property.
May be affected. That's a different story. May be affected. But what right? And the right has to be asserted. You should have a right. Then only you can come to the court for asserting that right. What right do you have? If you would have been an accused, you have a right to a speedy trial. So therefore you can come to the court. You are no one. You are no one. You withdraw this petition and move appropriate application. Learn counsel for the petitioner. After arguing for some time, seeks to withdraw this petition to resort to the other alternate remedy available to petitioner.
My lord, one pardon permission. No time they don't saras
Sorry?
Adjournment they don't. Seeking for adjournment. Not for withdrawal.
Okay. After arguing for some time, seeks an adjournment on the ground that her senior counsel, he is being led by her leader is not available today. Leave the matter. But you have to research and come. You have no locus standi. I simply adjourn it. Okay. Yes.
page 14 of the impugned order, your lordship will find, notwithstanding anything contained in the code of criminal procedure, the evidence of the complainant may be given by him by on way of affidavit.
Yes, you can give it. Yes.
Yes.
It is rejected.
Yes, it has been rejected.
Issue notice. It is rejected.
NI Act.
Issue notice. Not it though. First week, second week. Yes.
The proceeding may be stayed, my lord.
No, no. 138 no stay. 2 weeks I am giving. I'll allow you to lead the evidence.
Yes, madam.
Just formal notice I have to issue because the ex parte order I can't pass. Therefore, I'm doing it. I'll allow.
Obliged, my lord.
File the
On that ground, I will ask Mr.
File the
Leonard.
requisite. Nothing is going to happen within a week. I'll do it. File the requisites. Make sure that the service is complete. Huh?
Yes. I have to file requisites.
Yes. By tomorrow. Huh?
My lords, agreement between the petitioner and opposite party number 2, my lords, annex or 3, my lords, page 28.
Sorry, sir?
Annex or 3, my lords, page
Annex
28.
Okay.
And next 29 page, my
Yes.
lords, ଆମେ ଏଗମା ପକ୍ଷ ଓ ଦୁୟ ପକ୍ଷଙ୍କ ମୁତାବକ
You are challenging which order? Cognizance.
My lords, cognizance orders.
Yes.
22-24, my lords.
Yes.
My lords, both parties agreement and for opera preparation, performing of opera, my lords. Opera, my lords. ଆଉ 4 ଦିନ ପାଇଁ ଟୋଟାଲି 7,60,000 ଏଗ୍ରିମେଣ୍ଟ ହେଇଥିଲା ପର ଡେ 1,90,000 my lords. ଏଗ୍ରିମେଣ୍ଟ ହିସାବରେ ଆମେ 99,000 back case ଦେଲୁ and 2,23,224 ରେ ଦେଲୁ ତାପରେ ଅପେରାର 11/3 ରୁ 14/3/24 ଭିତରେ 4 ଦିନ ହେବାର ଥିଲା ତା 2 ଦିନ ପୂର୍ବରୁ 8/3/24 ରେ ଆମେ ଆଉ 1,00,000 ଟଙ୍କା ଦେବାର ଥିଲା କିନ୍ତୁ ସେମାନେ ଆସିଲେ ନାହିଁ କିମ୍ବା ଅପେରା କଲେନି କଲମ
check କାହିଁକି ଦେଲେ ତାହେଲେ
my lords page 30 my lords column 13 ଦୁଇ ପକ୍ଷ ଚୁକ୍ତିପତ୍ର ଦସ୍ତଖତ କରିବା ସମୟରେ ଏକ ଅଗ୍ରିମ ତାରିଖରେ ବ୍ୟାଙ୍କ ଚେକ୍ ଏଗମ ପକ୍ଷ ନିକଟରେ ନିଜର ପରିଚୟ ପତ୍ର ସହିତ ଦାଖଲ କରିବେ ଯାହାକି ଯାତ୍ରା ପରିବେଶ ପରେ ସମସ୍ତ ଚୁକ୍ତି ଅର୍ଥ ଗ୍ରହଣ କରି ସାରିବା ପରେ ଏଗମ ପକ୍ଷ
କେତେ ଟଙ୍କା ଆପଣଙ୍କୁ ଦେବାର ଅଛି
ଚେକକୁ
କେତେ ଟଙ୍କା ଦେବାର ଅଛି କହୁନାହାନ୍ତି
ଆମେ ସାର୍ ଆମକୁ ସେମାନେ 2,90,000 ରିଟର୍ନ କରିବା କଥା
these are the
ସେମାନେ
these are your defense
ଦେଲେନି defense no my lords এটা column 13 ରେ ଲେଖା ହେଇଛି
that's right I understand it there is an agreement you are relying upon that agreement has to be proved and record
my lords
and where is the original of this agreement
my lords annex or 2 lakhs I am paid
all these things you have to reduce in evidence sir 138 NI Act complaint have you replied to the notice given to you
no my lords no
you should have told all these things
not started
there is an agreement on the basis of agreement I paid nothing is said in the reply you have not responded to reply therefore 138 case is filed what can I do and all these things what you are saying all these things are your defense a presumption is operate against you that presumption is a rebuttable presumption you have to appear and rebut it then only will come out this is the law what to do I can't perhaps
only my lords notice
not is a formality that every case notice has to be issued if I know that I can't give you relief why should I issue notice why should I issue notice that's the whole difficulty if I issue notice then you have to deposit 20% will you deposit
no worries
then 143A I am disposing it Petition, or you withdraw more appropriate application for trial court. Invite an order. Petitioner seeks to withdraw the present petition. Petitioner is seeking quashing of the order dated 22/2/2024 passed by Learned JMFC Jajpur in CC case 1CC case number 221 of 2024, whereby cognizance of offense punishable under section 138 NIS against him has been taken by the court below. Relying upon an agreement dated, where is the date of agreement? Agreement dated 19/2/2024 and certain bank statement for the petitioner. Land Counsel for the petitioner submits that as per the agreement, he has already made good the payment towards the check amount, and the matter was also emanating in the the matter is emanating from agreed terms as arrived at by the parties, reduced down in writing, by the Juktinama, by the settlement, by the agreement dated 19/2/2024. The ground urged by the petitioner are the probable defense for the petitioner to be tested only in the trial, only in the trial, particularly because the petitioner has admittedly not replied to the statutory notice issued by the opposite party under section 138 bracket small b of NI Act. Hence, a presumption under section, a rebuttable presumption under section 139 NI Act operates as a thing. Since the presumption is rebuttable presumption, petitioner has enough right to lead appropriate evidence on his on the rebuttal of his burden, hence, I am not inclined to anything. However, liberty is granted to the petitioner to move application before the trial court in that regard. With this observation, the petition is disposed of. Yes. Next.
31.
May I please? The order of cognizance is under challenge at page 22-23. The offences are 366, 363, and 34. Lordship, kindly have a glance to annexure 3, page 21. The statement of the victim. The statement of victim does not make out a case of 363 or 366 against me. Allegations that
the cognizance is taken in 2020. Today you are coming after 5 years.
And your Lordship can.
And I don't know what is the stage.
In the meanwhile, the main accused and the victim has already compromised their matter.
That's a different story.
And I have been harassing. Your Lordship, kindly see
the principal accused.
What is the stage?
Someone was issued. I have not appeared.
Then
someone has issued. I have not appeared. Case is lingering. So I am released on bail by the.
But insult to the injury.
Since
you first of all 2020.
Your Lordship kindly see. Page 20. Your Lordship kindly see. Yes. Page 20 for a moment.
Yes.
First 3 lines. And Samantha Gowda stated as CCL. He is the main accused. Notice under section 41 CRPC was issued to CCL. Samantha Gowda as per the provision.
Norogoda. You are Norogoda.
Was arrested, released on bail due to his sickness. And thereafter, the sufficient materials is there. 363, charge sheet was submitted. Cognizance taken. Someone was issued. May I primarily let me appear and go on bail. That bail may be confirmed.
The other accused. How many accused were there?
2 accused, man.
The other one faced the trial. Got acquitted.
JCL, man. Juvenile.
Already acquitted.
Not acquitted.
Then
that instruction I don't have.
Now, what is the stage? Has the trial been completed? What?
That is let it be 1 week after, man. 1 week after.
No, 1 week. You tell me unnecessarily.
No, I don't have instruction regarding the other accused. Simply, this is the. Your Lordship kindly see.
And I even don't know what is the stage for the trial.
No, I don't, because Lordship, he is just.
You are coming and challenging in a cognizance order of
Cognizance order
2020.
and
You must know what
Lordship,
exactly.
kindly see I have received the certified copy in November 2024. Till then, no proceeding. Lordship, kindly see page.
Go and appear. I'll protect you for a month or so and let you go right off. The petitioner is in this petitioner is questioning the order dated 22/9/2020 passed by learned SCGM Koraput in GR case number 625 of 2020, whereby the cognizance of offences punishable under section 363 of the 366/34 has been taken against him. Besides the co-accused, Naragoda.
He is the Samantha Gowda.
Samantha Gowda. The petitioner pursuant to the summons issued by the petitioner during the investigation, petitioner was given notice under section 41 capital A.
Not petition, only Samantha Gowda. I was released on bail.
During the investigation, petitioner was granted, petitioner was admitted to bail. However, the co-accused was issued notice under section 41 capital A for CRPC. It appears from the record that the petitioner has not appeared before the court below. NBW has been issued?
No NBW has been
not appeared before the court till date. Till date. Then counsel for the petitioner submits that he has obtained certified copy of the proceeding up till certified copy of the proceeding up till date.
Certified copy, my lord. 19/11/2024.
Up to certified copy of the proceeding of the court below up till 19/11/2024. On the basis of the certified copy, he says that the trial has not proceeded in insofar as the co-accused not proceeded in inch. I am not inclined to entertain this petition at the belated stage. However, liberty is granted to the petitioner to appear before the. However, not then counsel for the petitioner on instruction submits that the client would be appearing before the court on or before the 10th of April. And the short to the remedy available to him under law. He further submits that since the petitioner was already, you are already on bail. What is the problem? Why should I give? Yes. You are already on bail.
Already on bail, but he is saying
and no NBW issue.
No NBW.
Where is it? Why should I pass any order? You are already on bail. Go and appear.
Yes, I will appear. Lordship, only there no coercive action, my lord.
What coercive action? There is no coercive process.
He says that
you are already on bail.
Yes.
No coercive process has been issued against you. Then.
So far the process is concerned, I
no. I can understand if you some coercive process is issued. NBW, I will stay.
Yes.
You tell me NBW date. Nothing is issued against you.
If NBW has been issued, I could come at Belgium matter, my lord.
So therefore, nothing is going to resort to the remedy available to you. That's all. With these observations, yes. I have written that you are on bail already. Yes. How can I regularize it?
The order is there.
Already there is
the end of trial.
And your default of not appearing is taken care of now. Your default of not appearing is taken care of. Yes.
May I please your lordship? In this petition challenge the order of cognizance dated 25/7/2024 in connection with the Lakshmi Sagar PS case number 238/24.
Sorry?
In connection with the Lakshmi Sagar PS case number 238.
What are you seeking? Quashing? Cognizance order. Where is that order?
Page 19, annexure 3.
Yes. What are the offences?
The place and time and date of occurrence specified in the FR which is lodged in Lakshmi Sagar PS case number. At the same time, petitioner appeared before the Katak Sagar PS in connection to the other direction of this Hon'Ble High Court.
Where is that? Where will I get it?
I have mentioned para 4 million. Para 6 of page 4 million. I have mentioned it.
Is 4. Let us see. Read it.
The petition in the time appealed with the IAC Kotak Sadar in connection to Kotak Sadar PS case number 359 of 2015. And the petitioner twice in a weekly appeared before this Kotak Sadar police station Lakshmi arrest that.
What is the time when you appeared, when incident happened? Nothing, you have not written anything.
Only Kotak Sadar PS time.
And where is the incident? Lakshmi Sagar.
Lakshmi Sagar.
Kotak Sadar, you appeared. You in the morning you might have appeared.
They have arrested me from Kotak Sadar when I was appeared before the Kotak Sadar.
So you might have committed the crime and might have come to appear. Who knows? You might have done the job there and they came here to the police station to appear.
Same time.
They arrested. What? Show me time. You have not said any time.
Only can Kotak Sadar police record can.
You have to tell at this time I appeared before Kotak police Sadar. Incident happened there. Where have you said and where is the document?
In the FR, they have stated that 12 noon, so and so.
And where have you said that at 12 noon on such and such day I was there at Kotak Sadar? And where is the proof?
That I can produce the proof only until.
That would be at best a plea of alibi. A plea of alibi has to be established in the trial only.
Until unless CD available, you can prove that.
You have to, unless you say then, see, if you say that thing and you say that I don't have this document, then I can ask for it. You have come to this court without making any averment. How can I help you?
During the investigation, in the course of investigation, the document could not be supplied.
No. You have to tell that at this time I was there. Then I can perhaps help you. I don't know whether I'll help you or not. Perhaps help you. But your averment is not.
I have taken such stand, but I could not furnish the document regarding support of my stand. At this stage.
Then I'm just adjourning it to file additional document. Or file an additional affidavit saying this particular time I was there.
Okay.
Then I just ask him whether he was there or not. But even if we confirm that you were there at that point in time, that is a plea of alibi, you have to test it. At least something should come on record. Okay. Let him, Mr. Mishra and Counsel for the petitioner seeks an adjournment to file an additional affidavit to lease the matter on so. You file affidavit and so after second week, first week. Yes.
33.
May I please, your lords? But here, my lord, the petitioner has challenged the order of cognizance, which is at annexure 3, my lord.
Yes.
Page starting from page 27.
Yes, sir.
Here, my lord, the cognizance has been taken on the basis of a protest petition, my lord, under section 294 and 506 of IPC, read with section 3(1)(r)
Yes.
and S of SC/ST Act, my lord.
What is wrong in it?
Here, my lord, initially the petitioner's mother had lodged a FIR against the complainant, alleging that I had purchased a piece of land in 2006, and since then I am in possession over that property. In 2021, the complainant came and claimed that I have also purchased the same piece of land from another person and trespassed into that property and broke the boundary wall of the petitioner's property. Thereafter, on the same allegation, the complainant filed a complaint case before the court.
Show me the complaint case.
Complaint case is at my lord. Page 11, my lord.
11. Yes.
And under 156(3), my lord, the FIR was registered. Thereafter, the closure report was submitted by the annexure 2, my lord, page 17, where the IO has stated that the case is nothing but a counter to the first FIR.
Where is the protest petition?
Protest petition I have not annexed, my lord.
No, don't give like that. You have to file protest petition. You have to file the statement recorded under 202. Then both the things you have to see whether the case is made out or not, that has to be seen. These are the two documents which you are supposed to file that you have not filed.
I have made the party.
Anyway, but you file those documents first of all. From those documents only you have to see whether any case is made out or not. Because you are challenging Cognizance on the protest petition. That protest petition and 202 inquiry report has to be there. File. Then Counsel for the petitioner seeks an adjournment to file the copy of a protest petition and the statement of witnesses recorded under section 202 CRPC. Lease the matter, second week, third week. Yes. Yes.
35.
Yes. What is this matter? Annexure 6. Cognizance.
34. 34. Right.
So pass over. 35.
Yes, 30 matter become interruption. 311 rejection was under challenge. In the meantime, judgment has been delivered.
Oh.
That is matter.
Matter has become practice. Yes.
Obligation.
36.
36.
Matter 36, I am appearing for the opposite party matter complainant. Now the case has been posted for argument authority or NIA case.
Lordship, this present petitioner is challenging. The petitioner is challenging the order where his application for sending the checks for examination of handwriting expert has been rejected, Your Lordship. Why he has sent, Your Lordship? The ground on which it has been rejected is that it is not the case of the petitioner that he has never issued the check. Whereas in the reply to the demand notice, he has clearly stated that he has never issued the check. So also the return memo, check return slip, that endorsement shows that signature mismatch, for which he has.
You are disputing your signature.
Yes. The reply also I have annexed, Your Lordship. May kindly see.
Where is that? You show me where you disputed the signature.
Yes, Your Lordship. The
A copy may also be
page 16, Your Lordship. Sorry, Your Lordship. Reply is at
yes.
Page 18.
18?
Page 18.
Yes. Yes, where have you seen?
Second paragraph, Your Lordship. Third line, my client had not issued any check in your favor, and also my client had not borrowed any amount.
Not borrowed is something different. Whether in the check you have signed or not. Your signature. Where have you said that?
Yes. Third paragraph. That it is presumed that knowingly and deliberately you have put forged signature in my client's name in the alleged check.
False.
Forged.
What did he say now?
argument page 18 goes argument. Final stage.
And
then section 73, let section 73, the trial court should compare the signature and decide it.
Yes. Lordship, the memo also I did not file because defect.
Oriental Bank judgment will not come in his way. Because once the check is disputed, the signature in the check is disputed, then he can ask for sending it to the FSM.
A copy may be copy in fast.
I will dispose it up because the matter is already in the final stage.
Final stage.
Under section 73, the court will compare the signature and decide it.
Court rejected my application because I had not given any specimen signature or check.
You give the specimen signature, let the trial court compare it himself. Under section 73 of evidence check. Do you have any problem? Because he has in the reply, he has taken very specific plea that the signature is
I will also take instruction.
What instruction? These are legal issues. Pass over, give the copy. I will pass the order.
Tomorrow.
Okay, tomorrow. Huh? Monday.
A copy may be sought.
Yes. Monday,
you give a copy immediately. Dispose it up.
Monday.
Yes, ma'am.
But that will not prejudice you, I tell you.
Monday
That will not prejudice you. Because he has to give a specimen signature and the trial court should consider, compare it and take a call whether it is original or not original.
Yes, Monday also must be completed.
Yes.
38.
That it. What is there? Yes. Pass over.
39.
Please, my lord.
Yes, Mr. Pona.
My lord, here, I, the petitioner was the complainant, filed the complaint against her own father. My lord, now under the pressure of her husband, and as well as the everything has been done by behest of that conducting advocate there in the trial court. So ultimately, she came to know, yes, that is a pressure practice, and also tried to misuse the petitioner. Now she wants.
Why have you implicated superintendent of police, IIC, everybody?
Because the investigation is last occasion, sir, my lord.
Who is Chittaranjan Patnaik?
Husband
of the
petitioner, present petitioner, the complainant there.
Son and daughter-in-law creating problem for the father-in-law.
Yes. Son-in-law only. Son-in-law. Now compelling her wife, that means the daughter of the
opposite party number 3 and 4.
Yes. To file this complaint petition, and also the complaint petition is pending.
What are the offences?
Offense, my lord, the offences is 174.
420.
Sorry. Oh.
424.
294, 354, 323, 506.
Family
420, 450. Yes, my lordship. Parents.
452.
Okay. Family dispute, I'll issue notice. Huh?
Only now she wants to withdraw that complaint petition.
Because they're the own parents. Daughter has filed a complaint.
No, she wants to withdraw.
Withdraw, yes. Complainant wants to withdraw the complaint petition. That is
Then who stops you? Where is the order?
This is the order. My lord, last occasion, my lord wanted to know.
All compounding offences, what?
No, my lordship. 420, 452, 294, 354, 323, 506 is there. Only 506.
The Lord and Magistrate also directed for the investigation of the case. Then the case has been registered.
164 statement was also recorded. But now she is saying that I don't want to pursue the
I don't
case
want
against my
to proceed with the
father and
complaint.
mother.
Against my father.
Where she has filed?
That is Bhubaneswar, sir. Yes, that is
where she is filed. What is it you are showing?
That is the last occasion I wanted to know the order passed by the magistrate for investigation of this case. That is the order.
Hi, this order is passed. Then what do you want to show?
I want to withdraw this complaint petition because I don't want to proceed against my father.
Have you moved application before trial court?
Yes, I have moved. With that observation, my lord can dispose of.
You move application.
Yes, with that observation can be disposed.
Because it is a complaint.
Yes.
Right.
As the complainant no more interested to proceed with the complaint, it can be withdrawn. Yes.
Petitioner is the complainant in one CC case. Which case? Case number? CC?
GR case number 424 of 17.
Oh, then many cases may not be compoundable. Therefore, 482 has to be.
Yes, my lordship.
482
506 is there.
Okay, issue notice. Issue notice. Take it totally. And reach it next week. File it.
Sir.
Because because 156.3 is involved.
Yes.
FIR is registered, GR case has already been converted. So he can't withdraw it now.
Yes, when
it has to be quashed. It has to be quashed. Okay. File the requisites.
Requisites.
Okay.
May I please, your lordship? Item 40, my lord.
Yes.
My lord, the petitioners are the in-laws, my lord. The OP number 2 has as informant. She has, my lord, lost a criminal case under section 498A, 323, 341, 34 of the IPC.
Issue notice.
My lord.
498A.
Yes, ma'am.
And diverse proceedings she has also instituted, my lord.
He is also.
After lodging this case.
But here they have prayed for the.
Who are you? You are the.
We are the in-laws, my lord.
In-law. She has filed the divorce.
My lord. Diverse proceeding, my lord.
So why don't you go to mediation?
My lord, later, my lord, if you are thereafter, we will go to mediation.
You go to mediation.
My lord, 2 proceedings. One in DV Act.
Are you interested to stay with her?
No, my lord.
She has filed the divorce petition against you.
No, against, we are the in-laws, my lord, against the husband.
Okay, against the husband.
My lord.
The husband is interested to stay
No.
with her.
My lord,
Reunion is possible.
my lord, reunion is not possible, my lord.
Then it's money matter now.
No, money matter. That's why, my lord, let the OP number 2 appear.
Why to waste one hearing? I'm just staying the proceeding and sending it to mediation. Matrimonial.
In another matter, your lordship will please to direct them to attend the mediation. That is in a DB case. So she will also, if she will also appear in this case, my lord, if that report comes, everything will be settled.
Give the particular of that.
My lord, that I have given, my lord.
Issue notice to opposite party number 2. Leave the matter along with
CRLMC 227 of 2024.
24. Yes.
But I pray for stay further proceeding. In this
Stay
case.
for the court. I'm staying it. Because mediation is going on in that DB proceeding. Let it be. Yes. Stay for. Yes.
Right.
Then there comes about the petitioner submits that between the opposite party and the husband, the other proceeding being the another criminal MC number 2272 of 2024 is pending before this court, which is emanating from a DB proceeding. This court has already referred the matter to the Orissa High Court Mediation Center. In view thereof, the proceeding before so and so is stayed.
Secretly, to continue hold the chadi dijandi lordship, ma'am.
I am saying this proceeding now. Yes. Yes.
Item 41, my lords, the FIR was registered in the year 2018, my lords, and the allegation is that the petitioners who were the members of the Home Guards Association, they were alleged to have caused obstruction to the public road in Bhubaneswar, my lords. The petitioners, my lords, they are out on bail, but since 2019, my lords, the charge sheet has not yet been filed, and because of which, my lords, the trial is not proceeding, and my lords, as lordship has observed, and the Supreme Court has observed that the right to speedy trial is a right of the accused, my lords, as per the Vakil Prasad Singh judgment in para 15. I only pray that, my lords, let the investigating authorities file the charge sheet and let the trial be expedited.
If they will file, if I force it them, then they'll file a charge sheet. Otherwise, they may exonerate it. Why are you inviting this?
It's because of, my lord, the
investigation is going on. If some order is passed from the High Court, they may file a charge sheet implicating you. Why are you inviting all these things? Let it be.
My lord, the difficulty.
And otherwise, they may exonerate you also.
Yes. But because of that, in 6 years.
You know the attitude
Yes,
of police.
yes, yes.
High Court order file kar do. Why are you doing that?
Because of
you
that,
know the ground reality.
Yes,
Apart from
yes,
that,
yes.
ground reality.
I bow down.
So why are you doing that?
The
Wait.
difficulty, my lords, to be very honest, not part of the governments. I'll be honest, my lords. The difficulty is that now a new notification has come for the recruitment to Home Guards. Now they are not because they are saying that because of this
pending investigation.
Yes, we will not consider your case.
If the charge sheet is filed, you will be more in difficulty.
Yes.
Did you follow?
Yes, my lords.
So let it be in the investigating stage only. That's the better idea. If you I pass some order, I have no issue. I can dispose it up saying that. But that will, ended up in a charge sheet. Today you are facing a affair. Tomorrow there will be a charge sheet against it. Don't do that. Leave it like that. Huh? Simply withdraw. Let us see. Wait for some time. Just check it, madam.
Yes, my lordship.
Check. Why? They are in trouble in the sense because of pendency.
Because they're creating obstacle. My lordship knows, and the complaint.
I'm not passing an order. I'm just requesting you. Just ask her so that she will speak to the IO.
Yes.
Go to her. She will speak to the IO and ask what is happening. Okay. Simply I withdraw it. Withdraw. Take it. Yes.
42, may I please?
Yes.
42, my lordship, that in the meanwhile, my lordship, the compromise petition I have filed, my lordship. Today I am supplying the compromise affidavit have been filed on behalf of the victim, my lordship.
354C.
My lordship.
376.
Informants.
They have got married and they have a girl child.
They are married.
Married.
Are they here?
They have
They
written
are
the
here,
wedding.
my lordship. That victim.
Just ask, madam.
Yes.
Dismissal Majboot is that I am using, my lord. If my lord will see the FIR also for a moment.
What are the offenses?
Offenses
61.
is, my lord, cheating, forgery, counterfeiting, and my lord,
Copyright.
Copyright is not involved in this case at all.
Copyright 63 and 103. 104. 103, 104.
Yes. My lord may see the FIR for a moment.
Yes.
My lord may see page 26.
Yes.
He is saying JSL, this is his trademark, my lord. Kindly see. This is his trademark. My lord, kindly see 26, my lord. The trademark has been given over here, JSL, profile tag. My lord may see. My lord, just compare with JSL Majboot. There is nothing, my lord. There is no similarity at all.
I am not trying to.
And secondly, my lord,
deceptively similar. All these concepts
those
bring in this.
those things are to be decided by the investor. Now, my lord, coming to the TM report. Search of trademarks, my lord, this is a computer generated TM search report.
Have you registered this?
Yes, my lord.
Very so me registered.
Yes, my lord.
So me registered. What is the offending trademark? Which one?
This one, my lord.
JSL Pro.
Yes, my lord. They say that it is JSL Pro.
Yes.
And my lord,
Show me the registration.
My lord, page 34.
34. Oh, yes.
Page 34.
What
My lord,
is the
column,
registration?
that is, my lord, 6563883. JSL Majboot. Dinesh Agarwal, proprietor of steel.
You are the JSL Majboot.
Yes, my lord.
But you are using as a pro.
He is saying that my trademark.
Then it has to be investigated.
My lord, he is saying that my trademark, this trademark, he is saying that I am infringing his trademark. My lord, but his trademark is not registered.
That's a different story. That's the reason he has not filed a suit for.
My lord, he has what is
you got what instruction you?
Yes, my lordship.
Instead of coming to the court, you should have done something else. You know that how to get out of it.
Very difficult.
See, paragraph, my lordship, I have just marked it.
Yes.
The report is sent by the ACP, my lordship. Another case
Jadi
was
upon
also
dekhibe informant ro, everything has been, my lord, objected. Informant ro trademark is objected. So if a trademark is objected, my lord, how I can infringe that trademark? Prima facie, my lord, there is no case.
Yes. Question of quashing doesn't arise at all.
Yes.
Now you just tell me de-sealing of the premises.
Yes, my lordship.
He may have a case for de-sealing.
Okay. But the trademark there says.
Particularly when a suit is not filed.
Yes.
And he will face the offences and he will be tried. But why? How can you de-seal it?
Yes, my lordship.
I can understand if there is an injunction suit, he would have been injuncted not to use that trademark. Then you can justify sealing because production center. The product you have sealed, you can prosecute him for having violated the product trademark. In the absence of a suit for injunction, the production cannot be stopped. Police can't stop. I can understand if they filed a suit and injunct him not to produce. The place of manufacture, how can you seal it like this?
My lordship, first of all.
Only confined to that. The rest of the prayer is to be rejected. You answer me that. In the absence of a injunction suit by the person, by the complainant, he is not filing injunction for obvious reason because he doesn't have a trademark registration. He doesn't have a trademark registration.
Yes,
has he applied for it?
No.
I don't know whether he has applied. You have not even Investigate.
Yes, my lordship, we have already.
Has he applied for it?
Yes.
No, no, no.
Is it pending? Any objection has filed
Objected.
by
It is
them?
objected, ma'am. I am given that.
Objected who? Have you objected?
No, my lord.
Then somebody else might have objected.
No, my lord. The register, my lord, that is the.
The objection. Do you know the procedure of registration?
First, they will file, there will be a notice, my lord.
Have you objected to it?
I have not objected, but.
Then the violation is apparent.
Report is there, my lord.
Apparent. See, the only thing is, in the absence of a injunction suit filed by the complainant, you can't seize the premises, because you are prosecuting on the basis of the violated seized products.
Yeah.
You prosecute them and whatever, but the premises has to be decided.
That they have to. Yes, my lordship, I will take the instruction.
Only to that extent you give instruction, get instruction. And the rest of the part you.
My lord, if I may kindly assist your lordship, I am the informant. I have not been made a party, but my all trademarks are registered. They have applied and it is objected. My learned senior.
Have you applied for that?
My all are registered in.
You have applied pro.
No, my lord.
They are
At
the
page 2 of my intervention, JSL Pro and Profile all are registered trademarks. Page 2 of my intervention, your lordship. At flags.
Why have you not filed injunction?
All Xerox already done. It is just going to be filed.
Then
all photocopy, everything done.
That's the point.
So
you should have filed a suit for injunction. You are not asking for injuncting them.
Yes, that
prosecuting these. You can prosecute, no problem. You can prosecute. That is, prosecution is a temporary violation. But permanent injunction, unless in the absence of permanent injunction, how can you stop their manufacturing?
Now, since the offenses are continuing, since they are manufacturing those same items using
then the
my
suit.
mark. Yes,
Then you have to file a suit.
that is going on. So I pray let them serve me a copy. I don't even know what is the case.
If they file the suit, take an injunction, then
What I am saying that at least more deceit, then anything might not happen.
Diesel point, I'm just asking.
Yes.
And how can you pass like this? There is an intervention. I don't know whether suit is filed or not.
Suit is filed on
Diesel, unless they give
instruction.
Next week,
Next week, बहुत दिन आराम बंद हो गया वर्कर गुड़ा का सैलरी पाई बनी किसी
25th. You are otherwise busy. Why are you wasting your time? You go and do something else.
He is my friend, my lord. I cannot run away, my lord.
Nothing will happen. You concentrate somewhere else.
No, my lord.
Okay. I'll put it on 25th. Okay.
Yes.
25th, my lord.
Yes. Next week.
Next week, at least Sombar also. I can manage him.
Monday is very difficult. Next week, I am not sure whether I can take up these matters.
At least no both problem.
Next week, my lord.
21st.
21st is बहुत देरी है. आज 12 तारीख है.
No.
At least next 19
Nothing is going to happen. These are businessmen and you are infringing registered trademark. You infringe and so urgent. What are you talking?
What I'm saying is this, my lord.
Not be sure that I'll deseal it,
My lord.
Don't be sure. I may reject it also.
Yeah.
My lord may reject it, my lord.
If the injunction suit comes, I'll read the plaint and thereafter I'll decide.
Kindly appreciate all these things, my lord.
I have appreciated.
My lord, the factory cannot be closed like this, my lord. Because, my lord,
if they obtain an export injunction against you,
they cannot do so, my lord.
They are trying it.
They are trying, my lord, but this.
So far, you have a good case. So far, once the injunction suit files, then I have to see the plaint.
My lord, they will file, then I have to wait till when they will file.
I don't know. Then
my lord, what I am submitting is this: they have already been directed by earlier court.
They have a registered. They have a registered trademark.
They have been objected, my lord. Status report says it has been objected.
No.
Yes, my lord. Kindly see page 30.
Have you objected?
This is, my lord. Kindly see forum.
It's already registered.
No, my lord.
They are
Objected.
He says already registered.
Where did my lord?
In the intervention, he says already.
32 page ता देखो ना वो किसी को नहीं सेमन कौन क्वेश्चन मुझे जानने 32 पेज से देखो ताको पाकर कौन डॉक्यूमेंट अछि 32 रे माय लॉर्ड दिस इज द इन्फॉर्मेंट लोगो यूजर डाटा JSL objected, my lord.
The objection might have been overruled. Objection might have been overruled. Registration has been done. Why are you
Wait a minute.
That is a year before, my lord.
Year before.
I understand.
Same दिन बाहर my lord. Same दिन बाहर There is no registration in the intervention application, my lord. Nothing is there.
Mr. Patnaik, objections are overruled also.
No, not overruled, my lord. खाली मुझे तो suffer करी पर
Next side. 21st. Only you want 19. Okay. It will be adjourned unnecessary. So 21st, I'm keeping it because I know I adjust my list like that.
Only request for the.
Yeah, I have given you 20 minutes. Although you don't have a case.
Case, I take my lord, but I have to do my duty.
Okay, 21st, huh? 21st. Yes. Compromise, yeah. Okay. 44. Offense?
307 3 SST.
Injury?
Injury report. I have the certified copy of the injury.
No, the MOS said that no, injury is no simple membership.
Place it on record, let him verify. Let her verify. 307.
Parties, they have come with big.
Party may come with their
Difficult is that the informant is the now government officer on
They are all the
after taking the leave, he has come.
Informant. Oh, I'll 2 o'clock. 2 o'clock.
Yes, sir.
I don't think I can hear because some issues are there.
No, my lord, I'm not no problem, my lord. If my lord, it is indicated that this honorable court that order goes. Probably the registry doesn't record it. I don't understand how it doesn't come.
Is it recorded there? Yeah. Oh, because another matter is fixed at 3:30, therefore they have not written.
Oh.
That's the reason. Next time when the matter is to be listed.
Listed. My lord, the difficulty is that he is superannuated. He can hardly hear. I mean, he has.
But today it may not be possible.
No, I'm not talking about today, my lord. My lord, give me a date, but I'll be extremely grateful, my lord.
Can you please give me some time so that I can just release and give at 3:30 I'll give.
Yes.
Okay.
My lord, give you a date.
90,
My lord also fix it.
93, na? The indication about 3:35.
93, I have already submitted my written note of submissions. I have already submitted.
Okay, we'll see.
They are indicated in the call list.
If a lordship permits, my lord, I have got another submission.
It's a parted matter.
Yes, Father.
Yeah, parted matter.
Another submission, my lords. Whatever the difficulties there, my lord, is to be directed to streamline the AC matter, my lords. The reasons they were ascribing that this is distributed in that code, this code, during this particular my lords. The rest to be directed to streamline the matters under all circumstances.
Streamlining the sense?
So the AC is not functioning. Sometimes it has a request has to be put forth. And
There
sometimes erratically they sometimes the quantity top knots. There is difficult to push up. My
the legacy issue. What to do? See, we are also facing the problem. If this side AC is functioning, they are in problem. If that side AC is functioning, we are in problem. There are a lot of issues. There is no control system.
Difficulty, my lord, is that it's in a way it is done. You cannot have an alternate also.
In Lords, the petitioner has filed criminal miscase for quashing of the proceeding on the ground of the compromise. Offense under section 126, 152, 351 to 296, 109. 109 is the 307 IPC.
What are the injuries?
Injury, I have filed annexer to my lord. Injury is simple in nature. Page 16. There
injury.
Page 16, annexer 2.
Head injury.
One knee injury, one head injury, and one neck injury, which is simple in nature. Three injuries are bruise. One knee, one forearm, and neck.
Simple. Huh?
Yes, my lord. Simple.
What have you used?
Use by iron pipe, my lord. Iron pipe.
And as per the affair, lordship, seeing a hottat luha pipe rod re mo hatore mundare mari rafta.
That's the prosecution case.
Ja phalare mu tale padigali o murcha hoi. O mate jibonare mari devi kahile o other slang language. Mor beko ku luha tarore bandi mari devi. This is the effect.
Allegations are serious.
Allegation is there, because injury is simple in nature, my lord.
No, maybe
And
simple, but your intention was to kill.
Injury are
That's the
bruise,
problem.
3 injuries are bruise, my lord.
I am happy for the informed.
You made so serious allegation, now you are come. What is the stage of investigation?
Charge sheet file.
Where is the charge sheet?
Charge sheet I have not.
Yes.
Where is the copy of charge sheet? You should have filed the copy of charge sheet. Why have you kept it?
Subsequently, I got.
You filed the charge sheet, let us. Let us counsel for the petition seeks that adjournment to please on the court the copy of charge sheet. Let him do so within a week, please the matter.
I'm happy for the
You have
informed.
to get over that judgments. Supreme Court judgment in even Gansing is creating problem for you.
Judgment.
Allegations are serious.
Yes.
Just check it up. Huh? File that, we'll see. Yes.
I'm happy for the informed.
Yes. Yes.
38.
Yes. 38. What is this matter?
38, my lordship.
Huh?
That is under section 294, 323, 427, 506, my lordship. It is there. Because of the previous enmity, my lordship, there is a FR and
What is they're asking for quashing?
Yes, my lordship.
Cognizance order.
Villages.
None appears for the petitioner even in the second call. It appears that petitioner is not interested to proceed with the affidavit filed EG, opposite party, settlement.
My lordship, I have not received anything, my lordship. It was showing in the cause list that affidavit was filed in flag A, but I have not received the copy.
Settlement.
Yes, but I have not received
On the
the
ground of the matter being settled, the petitioners have filed the present petition. However, none appears for the party in the interest of justice, at least in the July. Yes.
44.
None appears for the party even in the second call. 44, huh? Yes.
My lord, it is a compromise matter under section 307 and SC text 3.
Show me the injury report.
My lord.
Yes, injury report.
And
what are
for
the
the informant, my lord, injury is simple in nature, my lord, and
yes. Allegation. Read the allegation.
These people are the one of the person is petitioner number 4 is the MLA that time, and the opposite party is I think he is working as a video Tahsildar. There is a quarrel between.
What are the allegations?
Allegation under section 341, 320.
No.
My lordship,
only assault by the
Read it only assault.
My lord. My lord.
What are the offense, weapon of offense used? Where is
My
the
lord,
injury?
only a slap, my lord.
Where is the injury?
My lord, injury is my
Which
lord.
part of the body?
Upper lip, my lord.
Chest pain.
The simple in
Read, let us see the allegation.
My lord. Allegation, my lord, I am reading, my lord.
Assaulted him brutally on the day of.
My lord, so far is page 12, my lord, the FR, my lord, relevant portion, my lord. My lord, मते श्रीजुक्त सुभाष चंद्र पाणिग्राही विधायक मरणात्मक आक्रमण करते 2 गाल प्रबल 4-5 थर चापुड़ा मारी मुह फटई मुह पेट एवं पिठे लात मारे मते गाड़ी मध्यम घोषाड़ी नहीं आंसर लैंग्वेज कहीकि ये करें जो ओनली द विधायक
In the charge sheet also the same.
Charge sheet, my lord, Annex 2 lawsuit.
Charge sheet is the same way.
There is a counter FR also.
Counter also count FR, my lord, that already final report has been submitted.
Final report.
Yes.
My lord.
Counter FR filed by the
informant. My lord, petitioners. It is not for my lords.
Okay. Who is
informant?
The petitioner. Petitioner is. What is his name? Petitioner.
Petitioner, my lord, 4, my lord. Subhash Chandra Panigrahi, my lord.
6 petitioner, my lordship.
Where are they?
Akula Dhara.
My lord, petitioner, all the petitioners are present, my lord. And also informant video also present. my
Yes, first petition number 1. What
lord.
is
Petition number Akula Dhala.
Okula Dhalo.
Sir.
Who is the MLA? Who was there?
My lord, phone, my lord. Subhash Chandra Panigrahi, lord.
Chandra Panigrahi.
And in the cross FIR,
My lord.
petition number 4 is filed against the
My
video.
lord, against the video.
Video.
My lord.
Yes.
Who is Krishna Chandra Dalapati? कौन पे compromise करते नहीं आपण को इंडिविजुअली अटैक थोड़ी हितला आपण को दी पोस्ट को अटैक हितला इट इज नॉट यू ए पब्लिक रिप्रेजेंटेटिव हैज अटैक्ड ए ऑफिसर दैट्स द केस and they may attack another video sometimes merely because the representative doesn't mean that they'll attack the officers like this. Why have you done it? What is the compromise terms? This is at you are the officer and the OS officer, and at your free will you will file an FIR and sometime you settle with the accused and thereafter you withdraw. Is it permissible? Then have you filed falsely this case? Then what are you saying in your affidavit? Let us see. Where is the affidavit?
Joint affidavit also filed, my lord.
Where is that, sir?
My lord.
Yes.
Due to political, my lord, political issue, my lord. That's
They have written. We do not want to proceed the criminal.
Doesn't pay cost, heavy cost to the bar.
my lord. Also, political issue. my lord.
No, that therefore political doesn't mean that you go and
No,
attack
that's
the
my
police.
lord, my lord. My lord,
Video and all.
They
What
will
is this?
investigate.
my lord, he undertakes, my lord, not to commit such type of, my lord, in
Face blood
future.
up for the-
My lord, undertake to not to commit such type of, my lord, in future, lord.
No, no, you have to pay.
Consider it.
Yes, we cost to him also to the bar.
My-
Yes. That may be the sense of opposite party can do. The file number to be registered against the petitioners. The allegation against the petitioner is so. The after investigation, charge sheet has been filed in the present case on 30th August 2022 for alleged commission of offences, page 15. Offences under section so. The cognizance of the offences has already been taken, and before the charge is not framed.
No, my lord, the charge sheet already.
Charge is framed and trial is commenced. So the parties have entered into a settlement. The opposite party number 2 is the block development officer. Was the block development officer out? Which block?
Block development officer, lord, BDO, lordship.
Muniguda. Whereas the petitioner number 4 was the member of the legislative assembly, rather than MLA. The other petitioners are his supporters. All the petitioners and the opposite party number 2 are present in the court, represented by their respective counsel and identified by them. They have also filed the self-attested copies of their Aadhaar card to establish their identity, which are taken on record to establish their identity. The parties have filed a joint affidavit dated Ajit Bezio, Bharatini, entry stating as on para 2 to para 6. Para 2 to para 6. Para 2 to para 6. The opposite party number 2 who is present in the court on the query from the court submits that he is now posted. You are now posted where?
My lord, Raigada, my lord, video.
Now, today. Now, today you are posted. At the time of incident? Tilay body.
Devgad.
Tilay body. Video Tilay body. Was video. submits that at present he posted a video of Muniguda at Koraput Raigada district. Raigada district. He had lost the FIR against the petitioners when he was a video in so on the intervention of village entry and well-wishers. There was a settlement talk between him and the petitioners. They have settled the dispute out of court, and the petitioners have tendered apology for their misconduct, on the said apology. On the basis of the said apology, he has agreed to give consent for filing consent for watching of the FIR. Accordingly, the present accordingly he has filed the joint affidavit along with the petitioner. He further submits that he has already settled the dispute with the petitioners, and he doesn't want to proceed against them anymore. Mr. Marana appears for the state submits that the dispute, in fact, is interesting party. They have settled the dispute and filed the affidavit before the court. Although the involvement of a political leader, although the allegation reveals that the elected representative has attacked a officer. However, since the parties have settled the dispute, there is no legal impediment in questioning the FIR. Regarding to the fact that the parties have settled the dispute, and the opposite party number 2, who is the block development officer, has filed an affidavit before this court stating that he doesn't want to prosecute the petitioner, subjecting the petitioner to the rigors of the trial is destined to be a futile exercise. Hence, the case of the petitioner deserves merit and covered by the judgment of the Honorable Supreme Court in Quashing and Mother of India, so and so. In that view of the matter, the FIR, the charge sheet number so and so, dated so and so, emanating from the FIR number so and so, and the consequential proceeding arising therefrom are classed for the petitioner. Regarding to the nature of allegation and the status of the petitioner, I am of the considered view that the petitioners should pay cost of rupees 10,000 to the opposite party number 2, and deposit rupees 10,000 equal amount before the High Court, before the Raigada Bar Association.
10,000 each, my lordship. 10,000 each.
10,000 each. Raigada Bar Association. Raigada District Bar Association. Deposit.
May I please, your lordship? There are 2 FIR, my lordship. That should be mentioned, my lordship.
Which FIR?
There are 2 FIR. One is a FIR and the counter FIR.
But counter FIR, they have not filed anything.
Yes, my lordship, they have filed.
Counter FIR, my lord, final report. 3940, page 39, lordship.
They also submitted that at the instance of petition number 1, a counter FIR being FIR number
360, my lordship.
360, my lord.
360 of 2020.
They would PS, my lord.
They would PS case 360 for 2022 has also been registered against the opposite party number 2.
No, opposite party number 2 has filed an FIR against the petitioners, my lordship.
No.
They have given one FIR 361 of 2022.
That I was.
Yes,
and opposite party number 2 has filed a case. Petitioner number 4 has filed a case against opposite.
Yes,
This is the case.
In this case, my lord,
Petitioner number 4 has filed a case against this opposite party number 2. After investigation for the said FIR, a closure report has been filed. By, do you have that?
by FM number 553, dated 31/7/2022.
Closure report has been filed. Okay.
Page 45, 47, my lord, running page. Hello, oblige lordship.
45. Villain convicted under section 7 of the Prevention of Corruption.
Sentence.
Of the Amendment Act.
Sentence.
Sentenced to 3 years and a pay of fine of rupees 50,000.
Admit, appeal admitted, bail granted, and realization of fine state. Yes. Mr. Das. Yes.
46.
Item 46, the appellant has convicted a RA for 3 years and
Same order. Yes. Yes.
47.
47 Miller Belgium matter. Here Miller bailed out on 10/8/2022 and the NBW has been issued for non-appearance on 10/7/2023.
Okay. 1000. Yes.
48.
High Court of Orissa. High Court of Orissa.
My lord, Belgium matter, my lord. Petitioner is bailed out on 13/8 and 13 and NBW issued on 14/10/22, my lord, page 15.
What is? Tell with clarity what exactly the dates are.
Hello?
Tell the dates with clarity.
14/10/2022, NBW order issued, my lord.
14/10/2022,
page
okay.
15.
Bail?
13/8/13.
13/8/13. Okay. 1000. Yes.
49. 49, that's the Belgium, the petitioner bail out on 8/3/2017.
Correct.
So
24/12/2022.
22.
1000. Yes.
And Lordship, may
50.
I wrongly typed as a Sambalpur vigilance case number. That is the Baragar. Typed as Baragar. Sambalpur vigilance case.
Sambalpur
No,
vigilance.
it was transferred.
Transport to Sambalpur, huh? Vigilance case. Yes. Yes.
Item 50, my lord, bail dated 11th August 2021 and NBW dated 27th January 2025.
500. Yes.
51.
Belgium matter, my lord. Previously, he was arrested and subsequently released on bail, my lord. But NBW issued, my lord, recently, right, annex on, my lord, that NBW order was issued, my lord, on 4/5/2023.
23.
Yeah.
500.
NBW was issued.
1000. Yes.
Bail रे से arrested ହେଇଥିଲେ 20/4/1999 ରେ तापर subsequently 99 ରେ.
So could be on bail. Yes.
52.
Always.
May I please, my lord? My lord, here NBW issued in DV execution case under annexure 2, my lord, page 11.
Yes.
In execution, my lord, earlier expert.
What appear?
Yes, yes, my lord.
NBW has been issued in the DB execution case for alleged non-compliance of the maintenance order passed against the petitioner. Or instruction. Yes.
53.
Cost pokevani.
3, my lord.
Cost pokevani. DB case what cost? 4,500 per day. Yes.
Belgium matter, my lord. On 6/12/2010, under annexure 1, my lord, previous petition was released on bail, my lord. And thereafter, in 26/2024, under annexure 2, my lord, NBW was issued, my lord.
500.
54.
My lord, it's a Belgium matter. NBW issued on 17/10/2022, or they are under the release already, my lord. Bail.
500 each.
My lord.
Bill.
55.
The restoration petition, my lord. A dismiss for default. A restoration petition.
How much delay?
No delay.
No delay.
On time. In time filed within 1 month as filed and filed.
What do you want to restore?
Restoration, my lord.
FAO.
FAO, my lord.
For the reasons stated in the application, the same is allowed. The FAO number. FOA number
130 of 2020,
which was dismissed for non-prosecution by the ordinary date 13/7/2023 record, and the FOA is restored to its original file. Yes.
56.
56 pass.
On behalf of Mr. Patnaik, he is suffering from viral fever. Any day has to give April, my lord. I have taken consent already. I will take an opposite.
For the petitioner, and adjournment is sought on the ground that Mr. Patnaik is indisposed. Leave the matter. Yes.
7. Lordship, in last occasion, your Lordship directed the petition, respondent counsel to file objection to our limitation petition. He has filed, but that objection has not placed in the
Delay, how
record.
much delay?
159 days delay.
Yes.
Well, I have already submitted the copy, my lord.
I have the objection with me.
This is the, my lord.
I have the objection with me.
Yes.
Yes.
So, your lordship, similar matters, your lordship also. Your lordship shall also dismiss on the delay.
The same postmaster general and all this thing.
That's postmaster. Here is the case. The case has been disposed of at the time of a fresh admission. Only the page annexure A/3.
Annexure?
A/3. Page 11, 12. In view of the 12, in view of the aforesaid law laid down, this court is of the opinion that petitioner is entitled. Here the petitioner, review petitioner has not been granted time for filing any reply to the writ petition. At the time of admission, it has been disposed of.
Therefore, you have a case for LP. Writ appeal. Good case for writ appeal.
Yes,
it is set aside in all the matters. It is set aside. What did you review?
There were after
Yeah,
we
better,
got.
better, I'll tell you. Better you withdraw it with a statement that I'll file writ appeal. I'll record that and dispose of. Better you file a writ appeal because
Then
it's a good case. In almost every cases, it is set aside.
What happened when we have not given
The
we have
same
not
thing
been
only you
given
change.
the opportunity.
You change instead of writ petition, write writ appeal, file it.
Play lordship.
Let it come on a Monday. We will take instruction.
We
will take
to me, my
instruction.
lord. In a batch of cases filed before lordship.
I know, I understand, I know that.
Thereafter, thereafter, the 2 times they have rushed to Honorable Supreme Court. Thereafter, implemented the
Whatever,
order.
but in these kind of orders, when we, when I also sit with the Honorable Chief Justice as a bench partner,
Yes.
we have set aside. And the first day, without issuing notice, in a writ petition, dispose of, saying it is covered. You have to ask the other side whether it is covered or not.
This case is my lord. For your
Order is that
your lordship.
petitioner is entitled.
For that regime, the instant the stage of admission, this writ application or disposal of. In main case, they have near about 400 cases filed before.
I know all this.
One case, main case, they have gone to Supreme Court.
I know.
They have gone to Supreme Court.
Different factual aspects.
I know, in few cases, I appeared in Supreme Court. So therefore, I know each and everything.
Then you will say they have filed the review in the 2015.
But you better you withdraw it, file writ appeal.
Let it go.
Review, no review in this case, sir.
But we got some document that she is not entitled to the.
Then you file a writ appeal. How review is maintained?
Next week also we will take instruction.
Okay, next week. Huh?
Well, last week Monday, because why I my
Tuesday.
Yes,
Tuesday. 58.
58, my lord, 2 weeks time may be given for substitution.
Who died?
Opposite party number 5 and 6.
Opposite party number 5 and 6. They need to have 5. Therefore, the counsel for the petitioner seeks to is time to substitute to the LRs. Reach the matter after. Yes.
Good night.
Petition has been delay of 189 days with delay also. What a time honorable single judge being at the time of admission of the matter has been disposed of, directing the state authorities to regularize the service of the present opposite party number 2. My response submission also is that the honorable coordinate bench has relied the Umadevi judgment, executing the directive to regularize the service of the 2 in view of the judgment party Umadevi. My response submission also here is that the rest number 2 is appointed in, not appointed in a sanction.
1 minute.
Yes.
Again, the same thing I told Mr. Vishwa. You have a good case on writ appeal. Where is the question of review? Does it come up within the purview of a principle? Non-compliance of principle of natural justice is not a ground for review. It's not a ground for review. Tuesday, let it be Tuesday. You take a policy decision, ask, and make a statement. I'll give you that liberty file writ appeal. That's a better way to spoil your case.
In this case, there is no positive direction, as my learned friends submit.
Whatever.
Only direction to consider the case, nothing else.
Tuesday.
For regulation.
Kindly glance your lordship page 7.
Yes, yes, yes.
Tuesday, will you argue and get a dismissal today? Your only case is principle of natural justice. Principle of natural justice is a ground for review. Then,
Madam, there are 4 other matters, they have filed a review application in a similar cases, my lord. Lordship, may I pray that both matters also come along.
Tuesday, let them decide it. Tuesday.
60, I am the appellant petitioner in this case. Last date, issue notice to opposite party, direction to Honorable Court issue notice to opposite parties. But instead of filing required in limitation petition, instead of filing required in limitation petition, file required in CMPL petition. So,
wrongly you have had to do it. Okay. Press requisites. Okay. The counsel for the petition submits that he has inadvertently filed the requisites in another case.
Sorted file and file a limited petition.
1 week time to file press requisites. Press requisites. Yeah.
61.
Use mic. Yes.
In that case, the petitioner filed the case for quashing of the affair, as against him. But he was not present in that place when the occurrence was taken place. I have met the opposite party number 2 as the informant, and he has given the appearance. And the offense under section 341, 294, 354, 306. And on apprehension of my involvement, the affair was filed. In fact, I was no role in that case, and the opposite party 2, he has given the appearance.
I didn't call opposite party number 2.
2 is the informant.
What do you say, sir?
My lord, we are agreed to compromise, my lord. So, my lord, one date may be fixed and maybe.
What are the offenses?
Offense 341, 294, 354.
306.
306. Suicide କରି ମରିଗଲା ସେ ଝିଅ ତାର ସୁଇସାଇଡ କରି ମରିଗଲା.
Who are you?
ମତେ କହିଛନ୍ତି ଯେ ତମେ ମତେ ଏପ୍ରିଲ କରିଛନ୍ତି କାରଣ ମୁଁ ମେଳା ଦେଖିବାକୁ ଯାଇଥିଲା. ଯୋଉ ମେଳା ଦେଖିବାକୁ ଯାଇଥିଲା ସେ ମତେ କହୁଛନ୍ତି ଯେ ମେଳାରେ ହଉଛି ତାକୁ ମିସବିହେଭ ମୁଁ କରିଥିଲି ବୋଲି ସେ ମତେ କହୁଛନ୍ତି. This is the allegation against me. I misbehaved that
You are father of the victim.
Father of the
Are you saying that you have settled the dispute?
Yes, my lord.
କୋର୍ଟ କହିଲେ କୋର୍ଟ କୁ କହୁଛନ୍ତି କଣ ଏମିତି କଥା.
Have you settled the dispute with him?
No, ସିଏ ବାହାରେ ରହନ୍ତି, କେରଳରେ ରହନ୍ତି. ସିଏ ଆସି ପହଞ୍ଚିଲେ ହଠାତ୍ ଶୁଣିଲେ ଯେ ଏମିତି କଥା ହେଇଛି ବୋଲି ସାଙ୍ଗେ ସାଙ୍ଗେ ମୋ ନାଁରେ ଏଫଆଇଆର ଦେଲେ. This is the fact.
Are you arguing the case on merit or have you settled the dispute? That's what I'm asking. He says that I have settled the dispute with you.
No, dispute.
Be sure about it. That's what he says.
Dispute.
You decide, both of you decide what is your case, then I'll simply adjourn it.
No, there is
I'll
no
not do
dispute.
anything. You please go outside, have a cup of coffee and decide what exactly.
No, there is no dispute.
No. You have, and usually you give some thing, give it to him and decide it. Simply adjourn it. After 2 weeks, decide it and come.
The opposite.
Decide it, come.
The opposite one to make.
Next slide. He says something, you are saying something. Yes. You go on this speak with him. Have I told you? Therefore, I am saying that go for a coffee, both of you. Yes.
62.
On the last date of hearing, petitioner was directed to furnish the correct address of opposite party number 2, which has not yet been furnished. Therefore, for the notice could not be issued. Neither the requisites have been filed. In the interest of justice, one more opportunity is granted to the petitioner. Leave the matter in July. Yes.
64.
None appears for the petitioner.
64.
Notice issued.
No such person found under BT01. No such person found under BT01. Hence return to sender.
Notice was issued to the opposite party number 2, but the same could not be served. The postal remark indicates that no such person exists in the address given. Therefore, the petitioner is directed to furnish fresh address for the opposite party number 2. Lease the matter May.
65.
File requisite by tomorrow. Sorry, my file requisite by tomorrow.
Notice was issued to opposite party number 2 by the order dated 21/1/2025. However, the requisites has not been filed. There is not appearing for the petitioner. Seeks submits that he would be filing the requisite during the course of the day. During the course of by tomorrow. Let him do so. Lease the matter in May.
66.
My lord, in this case, petitioner challenging the arbitrary and illegally order, ex parte order dated 4/11/2024 issued by additional DCP cum executive magistrate, open number 2.
The thing is that my learned friend has filed an IF for change of the nomenclature to criminal revision notes. That is the 65.
Yes, my lord. I know.
Revision lies against this or what?
That is order of executive master 54 CRP.
You mentioned the revision lies there.
My lord, I know they are not already. The case has been infructuous. 2 months has already been elapsed before the but they are not but they are not giving any date to file a show cause or to any date or drop the case. But still in pending, and the petitioner number 3 is the president of the Durga Puja committee. Wrongly, PR report has been prepared by the IO, and order is
against this order of the additional DCP come executive magistrate is a revision lies.
Yes,
before the decisions.
Yes.
So why have you come here?
My lord,
Just withdraw it and resort to the right remedy under law. If cause of action subsists. If you say it is infructuous,
my lord, so then direction may be given to drop the initial proceeding.
If it is infructuous, why should I give that?
Not there.
And in a petition which is not maintainable, you yourself has moved an application, it is not maintainable. The petitioner seeks to withdraw the petition to resort to the right remedy available to him under law.
My lord, otherwise,
with such liberty, the petition is disposed of. But I have given that liberty, you file it. Revision, yes.
67.
My lord, criminal revision is not. Nomenclature is not any sense.
You have moved application. I have converted to revision because revision lies somewhere else.
I have filed for a stay of operation, man.
You say infructuous, you say it already infructuous, you say stay. Not sure.
Already, my lord.
You tell me one thing. Have you really prepared or not? I'll adjourn it if you are not prepared.
I am prepared, man.
Then you have moved application for converting it to a revision. Revision lies there in the district court.
As per
I can't convert it. At the same time, you are saying that it has become infructuous.
My lord, I filed the nomenclature petition as per stamp reporter.
But what exactly you want? You say that it is infructuous.
I want praying for direction may be given to the additional DCP to drop the initial proceeding against me. Already 2 months has already been elapsed, but they are not taking any steps to no.
Mr. Mohanty, what exactly?
Order passed under section 163 surplus 2 under BNS.
Yes.
That on the challenge. Registry is rightly pointed out that.
That report, what the order subsists today?
No, Your Lordship. That order was passed on 11/2024, Your Lordship.
So then,
near about 4 months already last.
Yes.
That order is for 60 days, Your Lordship. In the meantime, that order is annexed in the IF law, Your Lordship. So no prayer substance subsisting the.
That's what I'm saying.
That is the.
So then,
is already saying that.
you move application for dropping.
There. Yes.
The petitioner is agreed by the order dated 13/11/2024 passed by. Where is that order?
That is your.
4th 11.
This is item. 67. Yes. Order dated 4/11/2024 passed by the additional DCP come executive magistrate Bhubaneswar on the application on the proceeding initiated by on the proceeding under section 163 bracket 2 BNS. The life of the order under challenge has already expired. However, the grievance of the petitioner is that the proceeding has not been dropped as yet. In that circumstances, he submits that he would be moving appropriate application before the learned additional DCP come executive magistrate Barampur. He may do so with this liberty. The petition is disposed. Yes. You move on. Yes.
57.
Yes. Modification. What modification? What modification?
Modification of order dated 16 January 2025.
What modification is asking?
That copy has not been served.
Problem with file application for modification. अच्छा ऑन बेल लिख दी थी ना पारा तरीके ये पारा तरीके लिखा है कि पिटिशनर वाज ऑन बेल उसने हाँ ऐसा काट दियो काट दियो लिख दियो पता लिख दो petitioner is seeking modification of the order dated 16/1/2025 for 25. He submits that in paragraph 3, wrongly, it is wrongly it is inadvertently it is written that the petitioner has the petitioner was on bail. In fact, petitioner was not admitted to bail in the complaint case. Hence, NVW was issued. The process was issued against him due to default in appearance in the court. NVW has been issued. Accordingly, he seeks modification in para 3 of the order dated 16/1/2025. The para 3 for the same order 16/1/2025 is replaced by the following paragraph. The persons to the summon issued by the court of JMFC Basta, the petitioner did not appear in 1 CC case number 71 of 2024. Therefore, on 13/11/2024, NBW has been issued against the petitioner. Okay. Repeat. Okay. Yes.
69. Wait, please, Your Lordship. Item number 69, my lord. I have filed one IA that is flag E. IA number 2586 of 2024. I filed for acceptance of paper book, my lord. I have submitted 4 set of paper book.
The in the application, the same is allowed. The paper book, 4 set of paper book filed by the appellant is accepted. The copy of the same be supplied to the counsel for the vigilance. Yes.
And acceptance copy also one set for appellant, Your Lordship.
Yes, yes.
Grateful.
I allow copy.
And another date may kindly be fixed for the hearing, Your Lordship.
Weekly, sir.
Grateful.
Item 70.
Yes.
May it be, Lordship.
Yes. Passing up for the proceeding. 2cc.
This is the case which was initiated for offense allegedly committed under the Boilers Act 1923, Malad.
Yes.
On the last occasion, I had shown to your Lordship the Cognizance order at Annexure 5 is so cryptic. No application opined. Number 2, Malad, sanction has been given by a non-authority not competent. Number 3, Malad, I am not the owner of the factory. And number 4, there is no allegation whatsoever with regard to any kind of misdeed done by me. And number 5, the report based upon which the complaint was lodged, the name of the owner has been shown to be somebody else. And Lordship may kindly come to page 44.
44.
Yes.
Yes.
Page 57, I'm sorry, madam. Page 57.
Complaint.
Page 57 is the form D based upon which the complaint has been lodged.
Yes.
The complaint and this form D identical. Based upon this that has been lodged. The Lordship will find in page 57.
Yes.
The name and address of the owner is Milind Ramchandra Pingle. And the Lordship will see in that particular report the last page 13, clause 13, page 64.
Yes.
The violation.
Yes.
Before modification of the external furnace, the boiler owner, owner has been shown to be Pingle, had not correctly calculated the requirement of height and volume of the same. Further, due care was also not taken by the boiler owner to restrict the volatile matter content of the agro waste briquette within the permissible level, which resulted in less heat transfer from flue to water, due to which the furnace metal temperature increased steadily, causing stress in the weld joint and caused his failure. In view of the above, the boiler owner had violated section 12 of the Boilers Act.
Yes.
Boiler owner has been shown to be Milind Ramchandra Pingle. And Lordship will see the complaint.
Yes.
At page 46.
Yes. You are Mohan Singh.
This is Mohan Singh.
Yes.
As the owner. From nowhere, Malad.
Let us see the body. What the body of the complaint?
Same, identical. Whatever was there in Form D, this is identical. And Lordship will see in this particular page 46, I'll just show two of the by the director of the factories of boilers. What you got it, Millard?
Where you are reading?
Millard, just that clause number 3. Clause number 2 is the name and address of the accused.
Yeah.
Mohan Singh as the owner. And then clause number 4, Millard, sanction if any, where necessary. Sanction by the director.
Yes.
What should we just keep in mind? An offense, violation of section 12 of the Boilers Act.
Yes.
And Lordship may kindly come to here also the para 13.
13. Yes.
Page 51.
Yes.
Page 51, Millard. That
Yes.
para 13, which I read, Millard, from the form D, is identical and is the replication of the same. Before modification of the external furnace, the boiler owner had not correctly calculated the requirement.
Now the owner has changed in this. The PR report, form D says owner Pinglo.
Yes.
Here the Mohan Singh.
Mohan Singh.
That's the difference.
And Lordship may kindly
Let us see the body. In the body, whether any
identical
specific allegation against you.
No.
You are in charge.
No. That is also one of my grounds. No specific allegation.
Who is this Mohan Singh, Mr. Bishal?
Mohan Singh was an employee.
Right.
Yes.
In the
And he
form D, the entire allegation against the Pinglo, who is the owner. And you are trying to prosecute Mohan Singh. And come to section 12 now.
And cognizance has been taken for the offense under section 26A. Lordship may kindly see section 12 of the Boilers Act.
Yes.
Alterations and renewal of the two boilers.
Obviously, the sanction will be taken by the owner.
Yes, and who the person to grant sanction?
Yes.
Section 26, Parad.
26. Yes. Yes.
No prosecution for an offense made punishable by or under this act shall be instituted except within 24 months from the date of the commission of the offense.
No sanction is taken.
And no such prosecution shall be instituted without a previous sanction of the chief inspector.
Chief inspector.
And here Lordship sees that sanction at page 73.
Yes. 73. 3. Yes.
And sanction is against the owner. As point, Lordship with me, Malad.
1 minute, I'll just get it. 73, yeah? Yes. Yes, 73.
As pointed out in your investigation report, sanction of prosecution is accorded for the violation of section 12 of the Indian Boilers Act. We filed against the
owner of the boiler.
And by whom, my lord, kindly see? For director, non-entity.
How do you sustain this proceeding? Sanction is taken against the owner.
Yes.
Owner is not prosecuted, Mohan Singh is prosecuted. And sanction was supposed to be taken from the chief inspector. And director of factories is giving.
Not director, for
director.
Yes.
Even if you say that, okay, director, even director is not competent. Huh? Next week, can you change the facts?
No.
Malad, this case is, Malad, it has a checkered career, Malad. Earlier, Malad, this is the case of 2010.
It was dismissed in default. So
Default for no fault of mine.
Whatever it is, now restored. Forget.
The restored, stay granted, and not despite the stay granted, Malad, proceeding going on.
Yes.
We'll bring the status of the.
No, I have the status with me. I have the updates.
Why he has filed such a big volume of that small issue? Why have you filed so many papers and all?
The book company.
What is the status?
Case pending. And stay order restored by this honorable court. It's still going on. Despite the stay order being restored, it's still going on.
Then what do you say?
Next week, I will obtain the status of the case.
Certificate update.
Have you, Mr. Vishwal, have you read your objection counter which you have filed, such a huge counter for small things?
Yes, I have to go through that.
He is not prepared.
On the last occasion, they took time on the ground of taking the status.
The problem is every day the lawyers are changing. That's the problem. Last time Mr. Mohanty appeared. Now Mr. Vishwal is there. Next time we'll find someone else.
But I will be there continuing.
I passed an order. I communicated. I directed the order to be communicated to Learned Advocate General, saying that every hearing, why are you changing the lawyer? Because Mr. Vishwal has taken time. Next time somebody else will come. He have no clue what transfers today. That's the whole difficulty.
Well, in the present fact scenario, what more can be brought by him,
Yes.
The complaint is there, documents are there.
So many hearings taken place.
Yes.
Right now. By way of last opportunity, Mr. Vishwal fairly submits that he has not gone through his counter affidavit. Matter is heard, partly heard. You have argued, you concluded again.
Yes.
Mr. Das has concluded his argument. Mr. Vishwal to address the court and the next date appearing, please the matter on 24th wala week. It is made clear that no further adjournments are granted in this matter. In the meantime, the proceeding before continue to state. Yes. Yes.
Let's fix the date, Malad.
Yes, 24th that week. Let it be on 28th. 28th. Okay. Take.
Interim order. But I have shown to your lordship, despite interim order.
But you are not going 317, you move.
I don't know how.
Let your colleague get benefited.
Absolutely.
Somebody is appearing for you.
Absolutely, Malad.
You are a big shot now. Yes. Next. Yes, sir.
I was informed by the respondent today morning itself that he has some problems because his father is medical. But obviously, if his father has some problems, I will not say. There are two things I want. That I've already said. Yes. I will not object to the adjournment.
Yes.
Two things I just wanted to bring to your lordship notice. The chairman and 9 directors of IndusInd Bank is a multinational bank are the petitioners for lordships for a criminal case, for which there are a lot of difficulties they are facing because of the pendants of criminal cases. And your lordships are directed when order dated 28/11/2024 that this matter be heard at 3:30 p.m. and the date had been fixed, but it couldn't be done that day. So I will only pray that your lordship is passing the same order to be taken up.
See, the time, the time business sometimes.
But if the time is not even, but the matter is could not reach.
If you want, I can do that because earlier this order was
Your
passed.
lordship,
Let it be, huh?
26th, your lordship may fix.
26th, I don't know. 26th on some other matter is fixed, then you have.
26th or 27th.
Let it in the first week. Let it in the first week on 3rd.
Yes, third. But
Third.
your lordship may
3:30, yeah? 3:30.
kindly indicate that no adjournment because there already been
No adjournment shall be granted.
Your Lordship, I am on behalf of Mr. Shashwat Acharya.
Yeah.
He has argued for you.
Yes. Highly obliged.
And interim orders to continue.
Interim order to continue.
There are many cases, a lot. Interim orders.
Highly obliged, Lordship.
And come with you to ask your instructing counsel to prepare a note.
Everything is there. On record.
So that we can conclude the hearing. Because many matters are there. We can conclude that.
No, it is but what had happened, my lord, the first case and the other 4 cases, Mr. Ashok Mahanty is appearing, as an advocate. They are little different. Only the first case is to heard first. There is that's my case.
Yes.
Lord,
So get it now.
half an hour, within half an hour, or 20 minutes, my lord, it goes.
Okay.
Grateful, sir.
Highly obliged, Lordship.
72.
Matter has been argued at length. We are filing a note and closing it. Have patience nahi. Both of us were discussing, have patience nahi.
The long and short of your submission is, we got exhausted by arguing the matter.
We got exhausted.
Now you keep on writing, get yourself exhausted.
Passing on the buck to your lordship, whatever your lordship delivers.
But how to get out of this, that's what the worry was. How to get out of this WhatsApp messages? How will you deal with that?
WhatsApp doesn't establish the offense, and technically that offense is 376N, 2N. 2N is also not made out. Technically, the offense is 376 2N. 2N.
That's right, 2N, but
one. So therefore, one. That is one.
If these kind of evidences are there, and
WhatsApp.
That's what I told you how to deal.
WhatsApp is prior to the incident. One. And WhatsApp doesn't establish any after the incident, and WhatsApp makes no mention of this act.
No, WhatsApps are there.
Handwriting is also there.
No, handwriting doesn't.
It has been sent to the handwriting expert, the RFS,
that is different. Handwriting, but question is, why should I interact in a WhatsApp after such an incident for 1 or 2 years?
See the position you hold, and the position she holds. You may be having a relationship, and the relationship is gone wrong. It appears to be. That perhaps the reason she might not have given the complaint.
And then after comes back after 2.5 years.
2.5 years she might have
comes back. But even then, that would not be bona fide.
Then is exception 7.
That is exactly the case. That is exactly the case.
I'm giving the
Given my notes, and if necessary, I might supplement it.
Yes.
If necessary.
Grateful. Judgment is yours. 73. Hard copy. Petition. Already note of submission has been filed. Yes. 73. After restoration. Yes. Yes. It was dismissed in default, now restored. Nobody is now there. On 21/6/2023, the CRLMC, the present CRLMC, being CRLMC number 936 of 2021, was dismissed for non-prosecution due to repeated non-appearance of the counsel for the petitioner. Subsequently, the petitioner moved application being CRLMA number 219 of 2023, seeking restoration. By the order dated 11/2/2025, the CRLMC has been restored to its original file. Original file.
73.
Yes.
Sorry.
I was about to dismiss it. It was dismissed in default for consistent non-appearance. I restore it. Again, you are not coming.
No, my lord. Late hela.
Yes. What do you want to say?
My lord, it is a case. Preliminary charge sheet ହେଇଥିଲା 302 ରେ. Final charge sheet ଟା 302 କାଟି ଦେଲେ. କିନ୍ତୁ Cognizance sheet 302 ରେ ନେଇକି trial ଚାଲିଛି ସେଇଟା.
What is wrong in it? If materials are there, the court can take it.
No, my lord. Final charge sheet ରେ ଟିକେ ଖାଲି କହି ଦଉଛି.
It's all right. Merely because police filed a charge sheet doesn't mean that the cognizance court can't take.
Next, the process, my lord.
Yes.
302. Annexure 4.
Yes.
Final charge sheet hela, preliminary charge sheet hela.
304.
302 hela preliminary charge sheet.
But 304. Final form finally 304. 498.34. Cognizance is taken 302.
No, my lord.
Let's see the materials. What are the materials against you? Yes.
Well, Annexure 6, page 550.
Yes.
Commitment notification along with the record in city number 281/2020 received from the JMFC Soro committing the case record to the Court of Session.
Yes, I read it. Read it. Come on, come. Let us see. Let us see the charge sheet first.
My lord, sir.
What is it? What are the allegations against you?
Charge sheet page 42.
Yes.
As a prima facie evidence well made out under section 498A 304 IPC against the accused Gangadhara Behera, son of so 498A 34 against accused Hemalata Behera, mother-in-law, wife of so I submitted the charge sheet. Yes, case number 29/11/2020 under section 498A 304 34 IPC against them to face the trial. But page 43, minor, page 43, annexure 5, to face the trial under section 498A 302, 304B 34, I read with section 4 repeat.
Is a case of burn injury?
Minor, page 42 and 43, comparison, minor, 42.
That death of deceased Kausalya Behera is due to sheer negligence of the husband of deceased Gangadhara Behera for not providing better treatment. He had knowledge that in the event of improper treatment, it may lead to fatal consequences. This is the charge sheet.
Hey, how he received the injury? Let us see.
Well,
where is the statement? 161 statement. Not filed anything.
Well, a statement are presently not available, but I'll show.
How she sustained injury? I'm asking.
My lord, she while he was preparing for kitchen room, from her backside the straw set to fire. पाଳରେ ନିଆଁ ଲାଗିଗଲା ସେଇଠି ସେ ଥିଲା ତାପରେ ସେ ହଷ୍ଟେଲରେ ଥିଲା after she recovered after 5 to 6 months ମାନେ it was infected ସେ ଯୋଉଟାକ ଯୋଉ ଡାଏଟାରୀ କଣ୍ଟ୍ରୋଲରେ ରହିବା କଥା ସେ ରହିଲାନି ତ ତାର ଅକରେନ୍ସର ବର୍ଷେ ପରେ ସେ ଡାଏ ଏବଂ after discharging from the hospital when proper discharge.
Yes, what do you say?
The order dated 21 December 2020.
I do not want to
show me the statement of the
I do not want to avoid the trial, but the comparison page 42 and 43.
Show me the evidence of the witnesses.
Yes, my lord.
161 statement of the victim was recorded. When she was in the hospital for such a long time. Show me your statement.
My lord, take 1 week, 2 weeks. I'll produce entire.
Give me statement. This is pending since years for no reason.
The trial has been commenced from the
20?
2020.
ମାନେ କମିଟମେଣ୍ଟ ମାନେ ଚାର୍ଜ ସିଟ୍ ହେଲା ପରେ ଚାର୍ଜ ସିଟ୍ ହେଲା ଏଇଥିରେ 304
It's all right. Material is not there, you will be acquitted. But see, the kind of evidence you have, what I read it, then 302, even if charge is framed and advanced stage of trial, I will not interfere.
May I pray?
You may not be convicted for that.
No, my lord, I am not praying for acquittal or any to be discharged.
Your entire case revolves around the testimony of or the statement of the victim Where is that statement? You tell me. Without statement, you are filing and it is pending since years.
No, matter
How it was entertained, I don't understand.
only one is there. Last chance, I will satisfy.
See, when this matter is pending since 2021. Twice it was dismissed in default, restore, so many things happened. Main document is not there in the record.
I will place. It's a charge sheet.
Why it was entertained and why it is pending for 5 years? Without there being the real document is that victim statement. How the incident has taken place. Whether it is intentionally she was burned or inadvertently this has caused.
Negligence in setting is
that is your case, but show me the evidence.
Well, I will place. So, the hot state of mind. One week there, I produce all things. Only one chance.
There is no stay?
No.
There is no stay?
How much stay, interim stay?
I will vacate the stay. I'll vacate the stay. You can't in 302, you can't say, see, you took a stay order. It was remained dismissed in default. You didn't come thereafter. And thereafter it is restored. And now you have no files. Nothing. How can you stall the case like this?
Once next week also I will set.
Next week I can't adjust the list according to your,
I do not want for extension.
Very unfortunate.
Extension stay I do not want. Next week also I will satisfy.
Where is the stay order in source?
Stay order.
73, no?
22/11/21 it was.
Huh?
22/11/21. The coordinate dates is granted stay order. By I number 73 of 2021. Issue notice about further proceedings.
Let's see.
After dismissal, whether trial is going on before
2021, you have obtained the stay, enjoying the stay, got it dismissed in default, it is restored.
No, in the last occasion, this Honorable Court was calling for the records to show when the charge sheet.
I have called the record, I just see.
Charge sheet, if charge sheet was filed on section.
LTR is there with me. Yes. Let me see.
Charge sheet was page 42, madam.
Let me see. Let me see. The LTR is there, just check it up.
Yes, madam. Trial 498/304.
7 witnesses have already been examined.
ସବୁ ସେ 302 ରେ ହଉଛି madam. Charge sheet file ହେଲା ପରେ charge sheet file ହେଲା ପରେ preliminary charge sheet ରେ cognizance ହେଲା. Final charge sheet ହେଲା. Final charge sheet ରେ 302 ଟା delete ହେଲା. 304 ଆସିଲା. ପୁଣି ଏଠି ଲେଖା ହେଲା page 43 ରେ commitment ହେଲା 304B and 302. Page 42 and 43 comparison, my lord. Page 42, case is made out against under section 498/304. Page 42. But trial to face the trial for commitment hela 498/302 304B. Well, the court below, they felt that it is some kind of suppression of the final charge sheet was not brought to the record.
And Counsel for the petitioner,
this
matter is pending since 2021. On 21/11/2021, the interim stay for the trial court proceeding has been passed. The matter was subsequently dismissed in default, and the petitioner moved an application for restoration, which was allowed on 11/2/2025. When the matter is heard, it was found that the vital document supporting the case of the petitioner has not been placed on record. The petitioner is seeking one last opportunity to place on record the additional document to substantiate its case. Why we have last and final opportunity. If you would have been ready, I would have proceeded. The unfortunate thing is you people are also not ready. Last and the final opportunity, the matter is posted to first week, second week, and it's made clear that by the time if the additional documents are not placed on record, the interim order pass on such and such day. Interim order pass on such and such day, will stand automatically vacated. Yes. Second would be the order. Yes.
First,
second week. Yes. Next.
public.
Prepare and come, otherwise, see, these entry orders are operating, you people are not bothered. Yes. Yes, sir.
But see, page 14, the date of marriage is 14/5/2017.
Yes.
As per the affair. From 19th she had left the petitioner and the petitioner father and mother. By the annexed 1 series, the UP number 2 and all his parents and others, they have reached to the petitioner's father's house and they have taken all the things. It is mentioned in the receipts. That's the
Yes.
annexed 1 series.
Yes.
They have received, they have signed 3,30,000 on all ornaments.
Yes.
They have received and they have signed on 21/3/2021. After 8 days.
Money also they have taken from you.
Yes.
3 lakh.
Check.
Why have you paid money?
Matlab?
Why have you paid?
Because they have, at the time of marriage, they have paid the in check of.
That is sometimes it is so fatal, you know. It is tantamount to admission.
Yes, yes, they have paid.
So leave that apart. You
Yes.
tell me on merits.
And all the
So
ornaments.
it's a 498 case.
498. That
And 506, 34. At least section 4 is proved.
Yes,
you have proved yourself.
But she has left since 19. And on 21/3/2020.
Will you settle the dispute? Will you settle the dispute? Is there any chance of settlement?
There was a minor sent to the arbitration center, but it was failed.
Oh, then.
Actually,
It
divorce filed by the husband has also been dismissed.
But on 23/2021.
Dismissed and your lordship can.
But on 21/3/2001, he has taken all the things and money and.
That will not take away your.
Mother, I am saying, mother.
Yes.
Thereafter, after 8 days, he narrated the story that he was tortured from the 17th. He has taken all the things on 21/3/2021 and filed a FIR after 8 days. On 28/3/21.
Yes.
From 17 to 21, there is no torture. And even if he has tortured, he has not disclosed anything and not filed any FIR.
Why the mediation has failed?
My report is there.
What is the reason? You want to live together.
I want to live together.
13-1 filed by him, which is dismissed.
After receipt of the divorce notice, he has filed the FIR.
Those are not the relevant factors.
And it is the case under section 498A. See the FIR annexed 3 to 498A, 506, 34 and 4 IPC.
Yes.
The Grammar by the annexed 1, annexed 3 series has issued notice. Let's see for the moment.
Yes.
Page 21.
Yes.
No asile warrant habo.
Obviously, no warranty habo.
But Grammar has no authority to issue the warrant.
These are the grounds for quashing.
No, I'm not quashing. Quashing, I mentioned it is not possible. I have prayed. The court has no jurisdiction to decide the matter. Grammar for 498A, 506, and 4 of the DP Act.
That stage has not come. Now,
my prayer, my lord.
Only cognizance is taken.
No cognizance. My prayer to direct for transfer of their case to either Jajpur or Jajpur Road. I am residing in the upper Devna in the.
I am not exercising transfer jurisdiction. You have to resort to right remedy.
Proper application.
Right remedy. I try to help you out because it's a matrimonial dispute. Go and settle it up. You are not settling what to do.
No, she has not agreed.
The ground.
No,
That those are not the ground.
He has demanded much more, my lord, which I am not able to pay. Therefore, it was failed.
Then you should.
On to page 17.
70.
17. 17. Para.
In any case, you have created enough problem for her, for him. Leave.
He has created problem for me. So, your lordship may kindly.
How much you want, by the way, you tell me.
No, that is not the case. Your lordship may kindly, this, what has been stated.
Yes. Yes.
6-page FIR.
Relationship with another lady for which put me into immense torture. That is the reason.
That is in the 17, from 17 to 21, he was silent. He has not informed
But these
to
are not
anyone.
the grounds for quashing. You tell me, you raise all these points at the right stage. I will just withdraw and raise it. File a discharge application. Discharge application. Right on.
Because the father of the
Petitioner
number
seeking
2 is a influence person and a political
Petitioner
person. He threatened
seeking
will come and face the consequence.
The GR bracket GN case number 113 of 2021 initiated by opposite party number 2 against against them. The matter was referred to High Court Mediation Center by order dated order dated when it was sent by order dated. Yes, by order dated 17 to 2023, and by way of an entry measure, the proceeding before the Gram Nyale in GR case bracket GN number 133 of 2021 was stayed. The High Court Mediation Center has submitted a report informing that the mediation is unsuccessful. At this stage, learned counsel for the petitioner submits that he would be withdrawing the petition to resort to remedy available to him at the appropriate stage before the trial court by moving appropriate application. If such application is moved, the same shall be considered on its merit. With this observation, the petition is disposed. Yes. Next.
75.
Sorry to interrupt, my lord. The item 8330, my lord, is fixed. That AVP students, my lord, senior is there. I have come with a written order of submission. Nothing more submission, only note of submission I will give.
If he agrees, then only.
I will also file my submission. If he is so interested, written note. I will also give a written note. But
let him file.
Last occasion, my lord asked his associates who is present. You file your routine note submission. You also file it. So I am ready with this. I don't know whether my lord seniors come.
You supply the copy of written note.
Yes, I will provide this.
Mr. Party.
Already acquitted one minor has been acquitted. That lordship query flag C and flag B is the.
Want to argue.
No, Mukhari, I let go to want to argue. Kohidu sir.
Submit the note of submission and supply advance copy. 1 week, sir. 1 week. Yes. 1 week time to file his written note of submission. That's what the matter of the first week. Yes. Yes.
My lord is fixing any date.
Yes, 4th.
Here, my lord.
4th.
It is a challenge.
File by that time.
The order of cognizance.
Early date. 4th April take late use. Out take any date.
If not 4th.
Health and retail करबे आउ तो किछि नाही आपण तापर आपण
5th would be the safest time. Saturday. I can give full time. 5th.
Which?
5th of
April.
5th. Sir.
Saturday पिला खाली अच्छी चाकरी ପାଇଁ ବ୍ୟସ୍ତ न otherwise can it be 26th?
No, 26th that week you forget.
Achha.
Again you will wait, nothing will happen. Just see.
According to conventional law, my
4th or 5th. Are you
any date 4th and 5th?
4th. Let it be
4th. Yes.
Here, my lord, petitioner challenges the order of cognizance.
75?
Yes, my lord. Yes. Petitioner challenges the order of cognizance of option 31 of the Domestic Violence Act. On the 2 grounds, my lord. One, my lord, this petitioner is not the respondent in the DB case. Second, this is not a violation of breach of protection order, my lord. For section 31, say, my lord. This is not respondent, my lord, in the DB case. Section 31, say, my lord, if I lordship permit, I will place, my lord. Penalty for breach of protection order by the respondent, my lord. Section 31, my lord.
Yes.
It's petitioner not respondent in the main application DB, 12 DB protection act.
31, huh?
Yes, ma'am.
Yes. Yes.
31 say, my lord, penalty for breach of protection order by the respondent. A breach of protection order or an interim protection order by the respondent shall be an offence under the Act and shall be punishable with the imprisonment either discretion or term which may be extended to 1 year with fine, my lord. This present petition of respondent in the 12 of DB Act, my lord, which was annexed here with annexure 1, my lord. Page, running page 7.
What is your name? Your name is? Suresh Kumar.
Suresh Gantia, my lord. Annexure 1, my lord. Page, running page 7, my lord.
Yes.
There is a 3 respondent, my lord. One Somnath Al Vibhuti Bhushan Gantia, one Shivaram Gantia, and another is Apera Gantia, my lord.
Opera.
Yes, my lord.
Yes.
And that about, my lord, this 31 related to violation of protection, a breach of protection order, my lord. Here, this is a resident order, my lord. But you kindly see.
Who are you, by the way?
I am the brother of the husband, my lord.
Yes, sir.
Yes,
Can you maintain 31?
Yes,
without
it's maintained.
Yes. So,
that question is the good question in the present case. And on this ground itself, my learned friend has filed the application for quashing. But before going to section 31, let me see section 2Q of the DV Act.
2Q.
Ballot.
Yes.
Who can be termed to be an respondent? You got it?
Yes.
Respondent means any adult male person who is or has been in a domestic relationship with the aggrieved person and against whom the aggrieved person has sought any relief under this Act.
That's what he says. You have
I'm coming to
seek
that.
relief.
I'm coming to that.
Yes.
I'm coming to that.
Yes.
Provided that an aggrieved wife or female living in a relationship in the nature of marriage may also file a complaint against a relative of the husband or the male partner. Well, here, wife has filed the DV case against, say, 4 persons, 3 persons or 4 persons. 3 persons. Say 2 persons. My lord, accordingly, order was passed by the competent court. Now, the brother-in-law, who is not a party to this
The
DV,
original proceeding 12.
he had come and violated the order passed by the magistrate. Violated the order passed by the magistrate. If he would not have come, sister-in-law would have come. If elder brother-in-law, my Dersura would not have come, another brother-in-law would have come. So
No,
how many persons can be termed to be respondents in the DV case?
No, logically you may be correct.
That has been
The question is, if you have not filed section 12
well, I was
against someone,
yes,
can you maintain section 31?
It's a question. It's a question which has not been answered by our High Court in any case, any judgment.
The statute is very clear.
Here, my lord, it has been answered by Honorable Justice Sikri while he was in Delhi High Court. My lord, I'm just reading. My lord, I've prepared copy for my lord. Paragraph 12.
It is 31 is kind of an execution.
My lord, because this type of things, my lord, it can be decided by my lord only.
Yes.
My lord, we see paragraph 16.
16?
Yes. Beforehand, that is page 93. 2010, volume 118, DRJ, division bench, 83. But on the other hand, let me see second paragraph, before just paragraph 16. On the other hand, the wife or female living in a relationship in the nature of marriage is given right to file complaint not only against husband or male partner, but also against his relatives. Having dissected the definition, let me see paragraph 16. Having dissected the definition into 2 parts, the rationale for including a female stroke woman under the expression relative of the husband or male partner is not difficult to fathom. It is common knowledge that in case a wife is harassed by husband, other family members may also join husband in treating the wife cruelty, and such family members would invariably include female relatives as well. If restricted interpretation is given, as contended by the petitioner, the very purpose of which this act is enacted would be defeated. It would be very easy for the husband or other male members to frustrate the remedy by ensuring that the violence of the wife is perpetrated by female members. Even when protection orders under Section 18 or residence order under Section 19 is passed, the same can easily be defeated by violating the said orders at the hands of the female relatives of the husband. While not all the female relatives cannot be taken as a party as respondents in a DV case. Even all the male members in the family by, say, say, husband of my father's sister. See, he can also come and oust me from the house. So with the plea that I have not been taken as a respondent in the DV case where the order has been passed, so I can easily violate it. Well, at that answer, again, my lord, may kindly see how it has been construed.
18, para 18.
18, my lord, the detail. The answer is, my lord, paragraph 25.
Yes.
Well, let me see this.
Yes.
Fourth line. It is in this backdrop.
Since invoking the criminal
matter. Fourth line, my lord. I am not going in detail. It is in this backdrop, we have to appreciate that married women, wives are given rights to agitate their grievances against wide spectrum of respondents under proviso to Section 2Q of DV Act, which attempts to put an end to domestic violence and at the same time saving matrimonial home, which was not possible under the remedies provided in criminal law, and there was no such provision under the existing family laws. When this was the lacuna in law sought to be plugged by passing the DV Act, and the purpose was to remove the said mischief, leaving family relatives of a husband or a male partner out of purview of the respondent, would negate the purpose of which the DV Act is passed. Therefore, even the mischief rule of interpretation, commonly known as Hidden's rule, squarely becomes applicable, which persuades us to provide that a construction to the provision which shall suppress the mischief and advance the remedy and to suppress
it only says, the entire judgment only says that you can maintain a Section 12 petition.
Yes.
Being a respondent. Being a respondent, you can maintain. Who stops? You can file a fresh petition under Section 12.
Again, my lord,
that's the purport of this judgment.
My lord, the order has been violated. By whom? By a near and dear relation of my husband.
The provision says,
so it cannot be.
Each judgment says.
So, my lord, tomorrow I will include brother-in-law. Day after tomorrow, my lord, sister.
Unless you obtain an order under Section 12 on an adjudication, by undertaking an adjudication method, you can't, it is not in RAM. Section 12 order is not RAM. You get an order against XYZ, you want to implement.
Here the intention.
Someone else is not in RAM.
My lord, here the judgment, the way it has been analyzed, they have construed Section 2.6. 2Q.
In a very wider manner.
A wider manner.
Therefore, they say that you can file a Section 12 petition against anyone who has in a domestic relation. You can maintain it. But without filing Section 12, if you have obtained an order under Section 12 against XYZ, can you implement that order by filing 31
how can
against a person who was not a party?
Again, let me see Section 12 at this juncture.
Section 12. Yes.
Here also, my lord, while construing Section 31, I don't know, I was searching for this judgment, but I could not get it in this annotated edition. It has been stated, my lord, in this way, this manner: any resistance to the enforcement of the orders passed by the court under the Act by the respondent or any other person purportedly acting on his behalf shall be deemed to be breach of protection order or an interim protection order covered under the Act. A breach of protection order or an interim protection order shall immediately be reported to the local police station having territorial jurisdiction and shall be dealt with a cognizable offense while enlarging the person so and so, my lord. So it is any resistance by any relations, not the persons, those who have been taken as a party. And peculiarly till date, we in our High Court, no decision on this point is there.
That's the problem. And the statute is very clear.
Let me decide this next week. Wednesday, I will give a short note on this point. Let me decide.
You also get it. Because see, the problem is 31 is in the nature of execution. And it is very stringent condition. Unless there is an adjudication under section 12, how can you impose something against someone?
This question I will answer. I will frame this question.
And this judgment, very well, you can file a 12 petition.
And I will answer it. Answer it, and my lord may decide.
Have not made me party in my 12.
This judgment will not help you. On the basis of this judgment, you are a respondent under
the language
for the purpose of 12 only, not for the purpose of 31.
Well, the language is very wide. Construction of 2Q is very wide, and it should be that is the intention of the legislature while introducing this DV Act.
Then
I have got a
imagine a
situation. Imagine a situation. I have got a joint family of 50 members.
You implement one person, get an order, execute against all.
No, then I will execute. I will file application against 45. If I will leave 5%.
Just reverse, just see the reverse. You file one, it may be a collegiate petition. You can implement one of them, get an order and execute against all of them.
Contested in here they contested in the DV case, got an order against them. Here they contested in the DV case, got an order against them. I was giving a right to stay there.
I'll give an extreme example. In a joint family, the women files a domestic section 12 petition, impleading only the brother-in-law, gets an order and try to execute it through the husband, mother-in-law, father-in-law. Subsequently, it is found that the same lady has a relationship with the brother-in-law. How will you deal with it?
Here, my lord, here
it is a collegiate thing.
No, my lord.
You implead me, get an order, and
here I was staying in the house as per the order.
Possible.
I was staying in the house as per the order passed by the magistrate. By the persons, those who are respondents, they have not objected to the same. They have not interfered. As we taking the advantage of the fact that I have not impleaded my brother-in-law. If it can be constituted to be collusive, well, I have nothing to say. But brother-in-law has come forward.
On the facts of this case, it may not be collusive. I am giving an extreme example. So that is the reason the legislator were very careful about section 31. That's the reason. Because these are domestic relationships. You know? So therefore, the
persons, those who have not been arraigned as a party in the DV case, they can flout the order passed by the magistrate.
No, not that. That's not there. If you have not obtained an order under section 12, you can't proceed under section 31. That's you don't put it that way. Can you violate? It's not the case of violation. I can't have implementation.
Here in this case, I had no complaint against my brother-in-law. So I have not made him a party in the DV case.
But he is hindering now.
He has come, my lord, he has ousted me from the house.
So therefore, you satisfy me. You can. This is an anomalous situation.
My lord.
If somebody is hindering for
not hindering, I was staying there. He came forcibly ousted me from the house.
So section 12.
I draw the attention.
Therefore, section 12 again against him. That's the legislative intention.
But I will.
That's the judgment.
Let me say so, my lord will answer.
Yes.
Direct me in that.
Right, written. Yes.
My lord.
The interim order,
madam. Wednesday.
This is the there is just a
Wednesday.
Wednesday.
How? Very.
When is it possible? Wednesday may not be possible. 25th. 25th. Huh? But it is a very short point. You need
Short
not,
point, my lord.
yes.
Short
Very
point.
short point. It
But
will
I will
take.
prepare the short note, I will give it.
Yes. If you can get some judgment, you get it.
20, 20?
25th. Yes.
25th.
Yes.
25th.
77.
Mediation fixed to 18th. Urgent. Mediation fixed to 18th.
Lakshmi, 20, Lakshmi, I say, Lakshmi 26, and Lakshmi, I think 26.
Okay. Both the matter 26.
26.
This matter also 26.
Also, we have a difficulty on 26.
Okay.
27, 27.
So,
March, 27 to separate.
26 because when is the date fixed? 18th. Then 26th.
Now,
Is there any chance?
My lord, your lordship elected the opposite party to cooperate. He didn't turn up on that day. So.
But let us hope. Let us hope. Okay.
So, your
Lordship, due to illness, she could not appear before.
But on 18th, please appear and cooperate. Yes. 26th, I am keeping it for the mediation report. Let us see. Okay. Entry mode to country. Yes.
78.
May I please, your lordship? Here, my lord, the opposite party filed a complaint case. Opposite party number 2 filed a complaint case under section 138 of NI Act.
Yes.
That complaint case is 5 of 2013, my lord.
Yes.
Thereafter, he filed another complaint case. That is complaint case number 15 of 2013, alleging against the petitioner, alleging same plea as he has taken.
It's 420 for 120p and all.
My lord.
Can go together.
And that NI
can go together.
My lord, my humble submission before lordships, my lord, that complaint case was compromised before this honorable court in.
Will he compromise this matter also?
My lord, if your lordships kindly see the annexure 2, page 19, my lord.
Yes. So why don't you bring him in this case also? I'll quash it. Bring him. Notice was issued.
My lord, notice was already issued and
What is
appeared.
the position? Appeared.
My lord,
Bring him. Is he opposing this case? Bring him.
My lord, my lord. I will
call him. Despite the Mr. Who has entered appearance? Mr. Santosh Kumar Das has entered. Now reflect who? Santosh Kumar Das has entered appearance for opposite party number 2, but today he is not present. In the interest of justice, adjourned to so entry mode to continue. Yes.
79.
Yes.
May I please, Your Lordship? Plus, by order dated 23rd May 2024, plus notice has been issued. Plus,
yes.
In this case, what has happened? There was FIR was registered.
Yes. Yes.
Plus, and in the meantime, also opposite party has rendered appearance. In this case, plus FIR was registered under section 304A because the patient died while after her operation, the patient died in the hospital. That the reason was a complaint has been lodged and that FIR was registered under section 304A. So when final form was submitted, that was submitted under section 304. So my contention was how it can be a 304 because when it's consistently it has been written in the FIR that due to the negligence of the doctors and due to the negligence of the staff, the patient died. Plus in the final report, how it will be a case under section 304 where the intention to cause death is required to make it culpable homicide not amounting to murder. And your lordship has been pleased to issue notice. The opposite party has rendered appearance. And then in the meantime, development has taken place because the petition, the informant had also approached the Orissa State Human Rights Commission. And there a compromise has arrived at and the amount of around 5 to 6 lakhs have been paid and there that has been dropped. So that is the reason was why I humbly pray your lordship to interfere in this case.
You have paid 6 lakhs.
Yes, plus. And Honorable Human Rights Commission has been pleased to close the proceeding on that alone, on that ground alone.
Who is appearing for the informant then? Who is appearing? In his absence, I can't help you.
They have rendered appearance, but they are not appearing. On the last occasion also, none has appeared.
None has, Mr. Lakshmikanta has entered appearance for opposite party number 2, but he has not been appearing since last last 2 date of hearings. His name is reflecting the causes. In the interest of justice, last opportunity is granted to the opposite party. This is the matter from. Yes.
Plus, my submission may kindly be recorded because Orissa State Human Rights Commission has brought the proceeding on the ground of compromise.
The particular counsel for the petitioner submits that the opposite party had approached the State Human Rights Commission, alleging the same making same allegation. In the proceeding has already been dropped on compromised term. I will not write the money part, compromise.
Minors, no, not
compromise terms. And he submits that this is the parties have already settled the dispute. The present matter can also be disposed of in the same terms. In the same
minors, diploblazed.
Yes.
81.
Wait, please, Your Lordship. Your Lordship, in last 2 occasions, notice was sufficient and another chance was also given to the opposite party for objecting to the order of my proceeding, my lord. I am challenging here the order of cognizance dated 4/9/2023, my lord, page 18 of Annexure 1. My lord, in which I have been implicated under section 490.
Interim order in your favor.
My lord?
Interim order in your favor.
Yes.
Non-appeals for opposite party number 2. In the interest of justice, interim order to continue.
My lord, already did
interim order is there. Enjoy the entry. He's not coming there.
My lord,
I can't hear because I have tried it 3:15. 4:15.
My lord, is short. No, my lord.
He's not saying that.
My lord,
interim order.
My lord, proceeding.
82.
My lord, is short.
Yes.
82.
My lord, in the item number 82 and 83, I am appearing for opposite party number 2.
Yes.
My lord, the petitioner has filed the IA but not served the copy to us.
Yes, Mr. Mishra, save the copy.
My lord, 3 weeks time.
So entered appearance for opposite party number 2 and submits that the copy of the petition has not been supplied to him. Let Mr. Mishra undertakes to supply the copy of the petition. Leave the matter up. Yes. Interim order to continue. Yes. 82, 83.
May please, Your Lordship.
In item 84, I have appeared in first case. Though the petitioners in both the cases are the accused persons, whether they have made me party in the second case or not, I don't know.
Second
so
case?
let a copy of the third case may be served on me so that I.
Second case also she may appear and make her submission. But the second case.
Allegation, my lord.
Second case, you are not made party, but you can appear in the first case.
The allegation, my lord.
Arranging out
That the allegation made in the year 2009.
I had made party.
Yes.
He's never appeared. Expired. He said expired.
With the inference expired. Inference expired, you are actually directed to his wife should be appear.
Despite several notices, he never
Why
appeared.
he substituted
Informant has been-
in the place of informant?
His wife is
appearing.
Okay.
Informant's wife.
Yes,
So
informant.
allegation-
Yes.
Lakshmi may hear my learned friend.
Mana-
Possibly, he might have some details to tell you, Lordship, which will be.
Second matter.
First
Yes.
matter, first matter.
First matter, my lord.
That is
I have to file
159.
objection.
Yes. The case is, my lord.
I may be permitted to file objection in both the cases.
Let him file that. In the second matter, you have made
Last
a
document
report.
also she has taken
I
that
said it
time.
appeared, nothing.
Now the case is very simple manner.
Very simple.
It's very simple manner.
See, here to make it complicated.
I will file objection.
Well, lawyer is-
गाड़ी कौन सी लोन भी नहीं.
Case complicated, we can't help it, my lord. If it's a lawyer-driven litigation, I don't know. But, my lord, the initial allegation was in the FIR, and that is the investigation also. That my learned friend's client,
Yes.
he had sold a vehicle to to her. Now her, which is husband lodges the affair. Now, she finds out that after the sale, she paid 8,20,000 to him. After the sale, she finds out that no, the loan has not been cleared, so the vehicle is still encumbered with ICICI Bank, from whom he had taken a loan to purchase that vehicle, and he had resold it. Now she returns the vehicle to him. She waits for a sufficient time and returns the vehicle to him and says, "You return my money back."
Money was paid.
Wait.
No, no,
1 minute,
no,
1
he has
minute.
not paid.
Can you allow me to
Yes.
Can you allow me to complete? We'll have it. I think. Then she says, but she finds out that a fraudulent NOC was issued and the vehicle has been transferred to my client.
Yes.
So she comes to my client and tells me that, look, this is what I said. Look, I have taken it on refinance from Tata Finance, and you do whatever you want to do. I'm no way concerned with your dispute with Mr. Padhi or whoever. Now the police files a cash sheet. I repaid the entire loan. Tata Finance also had appeared before your lordship and they submitted before your lordship that they had done the thorough check and they got a clearance, that there was no encumbrance. Therefore, Tata Finance had refinanced. So if they would have been,
I understand.
they would never have refinanced to me.
What do you want, madam, exactly now?
I'll tell you lots of things. Just two more sentences will, I
Yes.
think, will take care of it.
1 minute, 1 minute.
Today, Bana.
I am the
So your lordship,
1 minute, one.
lordship had heard the entire matter and closed my part.
Yeah.
Now my friend comes, he's in anticipatory bail, he files some documents, probably he'll be filing or whatever, that he has returned that 8,20,000, which was the
To the husband.
Yes.
Of course.
to
No,
the
no.
husband.
He has
That
not
receipt, that receipt.
Madam,
was-
see, nature of allegation, what I understand is, you can settle it. Why don't you go to mediation and settle it?
It is settled.
Huh.
He's not giving the.
See,
consent.
you don't know whether your husband has taken.
He is not giving the.
That
consent
husband
to refund the
incidental.
money.
Husband
Shall I send it to mediation?
cheater.
Shall I send it to mediation?
Yes.
I'll send it to mediation.
Yes.
Point. Otherwise, see, in his case, I have made up the mind to quash it. Because he is unnecessarily roped in this case. Because he obtained the loan after
I
getting
cleared the
clearances.
No, more loan test is
So therefore, there is some small technicality. Therefore, you are trying to encase it. It's not fair.
Incidental.
Refund of money.
And your husband has also died. So what do you want from out?
The refund of money.
What refund? He says that he has
also
also.
kindly see. This is
Really sorry.
loan position
Your client is trying to ambush to get some money.
6.5 lakhs loan lechay.
Just see his signature is there.
It's up to me.
I'll send it to mediation and try and give some, if possible, give some money and finish it up. Unnecessarily. 1 minute, not on the record. Off the record, I'm saying. Ultimately, he needs some money. You pay it and finish it up.
Needs
I'm
some
telling
money.
you. Huh?
With my money.
I guess
Eight
your
lakhs
mobile manager काम करता है. So
Regarding head to the nature of allegation made by the opposite party against the petitioner to file in the FIR. I'm of the consent review. The parties can explore the possibility of a settlement before the mediation center. Hence, the matter is referred to High Court Mediation Center.
The first case. Second case will be reserved. Closed. I'm in the second case.
I'll both the case I'm sending. I'm clear that your case it has to be quashed.
I will not appeal.
Yes.
Well,
In the criminal case, he has alleged that I sold the money to Mr. Pujari.
Madam, I'm giving only one opportunity. You explore. I'm putting it on 5th of April. I'm fixing the date 18th at 4 o'clock before High Court Mediation Center. 18th at 4 o'clock. 18th. ଆପଣ କ୍ଲାଇଣ୍ଟ ଆସନ୍ତୁ ନା ଆପଣ କଣ ଆସି କଣ କରିବେ ଆପଣ ପଇସା ଦେବେ ଆପଣ ଯିବା ଦରକାର 20 okay 20 at 4 o'clock and after exploration of the settlement and lease the matter on 5th. Yes. Saturday you come and
5th I won't be available. So,
Let it be 4th then.
no, more to week down nine.
6th, 7th, 7th,
7th.
7th. By 7th, you try once. If happens, then both the things I'll pass, otherwise I'll pass.
Entry model may continue.
Entry model will continue.
So, Ashwin specify only his client will appear.
Yes.
Great.
His time also to appear, because allegation is that I have sold him to my vehicle. That is the allegation in the criminal case.
Madam, you try, let us see what happens.
Yes.
Yes.
Informant. I feel your lordship has issued notice. Cognizance challenge the cognizance taken under section 506, my lord. Dispute between the two professors, my lord. Allegation is that he has telephoned and abused. That is the allegation. Your lordship last directed to.
What are the offences?
506 only. And that telephone never has been seized by with regard to the use of that.
Yes, Mr. Mishra. Your client is serious. Your client is still serious.
Yes, yes.
Many people scored, many people what?
I know both of them.
Both are the educated, both
I
the
know
professors.
both of them. This principal as well as that person also, who is the petitioner before this Honorable Court also.
Shall I send it to mediation? Let us send.
Yes.
Send it to mediation. It's only scolding 506 and you people are so highly educated.
Why
don't you do that?
He hasn't. Your lordship can visualize.
I know
He
that.
has taken the telephone and the person has not used the telephone and the owner of that.
You tell me one thing.
That is the technical.
Will you tender apology in this court? Tender apology before this court and Quashing. I'll Quashing. File one page small affidavit saying that out of
not repeat this type of thing.
What he has documented. Your lordship kindly peruse the affair.
Serial report.
What he has used?
How many cases are there?
Nothing, my lord. Because of the personal animosity and personal ego, and the sub-collector who happens to be the relation of the informant, they have pre-planned everything, my lord. Because he was the.
Then if this is the ego you have, then I don't think mediation to teach about.
Ego nahi mu to public chamber re koi dun tar
let both the party appear.
Yes.
pathai dun mediation pathai dun se jodi hobo tapare pass kar
let both the party be present here, otherwise the mediation will start fighting.
Class bunk kari
online appear hotu.
Again, online appear.
Online appear hotu. I'll decide it here.
Again, yes. That is better.
Better unnecessary mediation पटेवे सेठी पुनी झगड़ा फायदा कौन?
झगड़ा
किसी झगड़ा नहीं only because
let them appear in person.
One is the reader and another one is the principal.
Both are reader. Both are reader. Both are reader.
I know both of them because they are nearby faculty place.
Personally, both the petitioner and opposite party. Put it on next week. Okay. 28th. 28th. Personal appearance?
Yes, ma'am.
Through online.
Online appearance. One reader and
I know.
Both are reader. Both are reader.
Holding.
This reader has got everything without going to college.
That's the problem. That's off the record.
Allegation can be made against God, my lord.
It's true.
Okay. Yes.
The rest of the matter may be tomorrow.
Lordship, pardon to mention. Pardon to mention your lordship.
9
the 5 matters remain. It will be spillover to next week in 5 days, continuous.
Yes.
Tuesday to Friday.
Item 92 may come after sometime.
92? Okay, that's good. 92.
Mr. Maharana is not there.
Then Mr. Maharana is not there. Okay, the second week April. He's not there.
Third week.
Third week also. He's not well.
Your Lordship, pardon to mention.
ତିନିଟା ବେଳକୁ ତ ଦେଖୁଛନ୍ତି କେମିତି ହଉଛି ନା, ସେଥିପାଇଁ ତିନିଟା ବେଳକୁ ରଖିଲେ ପ୍ରୋବ୍ଲେମ। ଆପଣ better make up your mind after 3 o'clock you come and sit here. After coming, if I get, I'll pick up the file and do it. That's better. Fixing means again it's a pressure on you and pressure on me also. After 3 o'clock, I told even in the criminal appeal, wherever, if anybody is there, I pick up the file 1, 2 and do it. Okay. Okay.
One week after. Your Lordship.
Which one?
Next week after.
And when you will come, you bring him also. Otherwise, you know what happens. And after 3 o'clock every day, you should be here.
I am remaining here.
Yes.
Only.
I may pick up any appeal. Mr. Rizvi was there, 2 appeal we could hear on that day.
So that is parted.
One parted and one judgment reserved.
2010
हाँ आपण भी रही गले खत्म ही जो 2016 छोट छोट मैटर गुडा
मोर मु कहूची जे खाली प्रेयर करछि जे याकू इंटरवल ले आनले गोटे दिन रे 3टा अपील आर्गुमेंट करि होबनी
गोटे हो ना 3 दिन स्पिल ओवर करियो ना
तेनो 3टा अलग अलग वीक रे आनले आई कैन मैनेज
थाओ अपन थाओ
Lordship, just one mention.
Mr. Respected senior counsel mentioned before your lordship that is part art 93.
Yes.
93 already argued. That is a DA case. Both of us have
स्पिल ओवर कर दे नेक्स्ट वीक स्पिल ओवर कर ठीक है स्पिल ओवर कर
both of us have argued.
Lordship, item 88, just a hearing matter, 2010 matter, Your Lordship. Place it in next week.
I have already told. Don't worry. I have already told.